Okay, ZBA, we are live. We are recording. Phone lines are open. Go for it.
Thank you, Matt, and welcome everybody to the Town of East Hampton Zoning Board of Appeals hearings for September 13th, 2022. We have one canceled public hearing this evening, and that is Wickapog Realty LLC, Wickapog Realty 1 LLC at 391 East Lake Drive in Montauk, Suffolk Tax Map number 300-7-3-5. That brings us to our first scheduled public hearing. And I'll read that into the record. The applicant is Miller Brothers Hospitality LLC, located at 28 Maidstone Park Road in Springs, Suffolk Tax Map number 300-38-4-22.1. Again, the applicant is Miller Brothers Hospitality LLC. The size and location is 6,899 square feet at 28 Maidstone Park Road, Maidstone Acres, map number 664, Section A, Block A, lots 1 through 3, filed 6/5/31, Springs. The description is an appeal of the building inspector's determination dated March 28th, 2022. The relief sought is an appeal of the principal building inspector pursuant to 255-835A 1 of the Town Code. Appellants seek to challenge the determination finding that catering businesses on site represent additional uses. The zoning district is NB Neighborhood Business Zone X Flood Zone. The secret class is Type 2. Council, do we have a proper affidavit of service and posting?
We do have a proper affidavit according to the notice and hearing provisions of 255, Section 9, Section 23. However, I did speak to council prior to this meeting, and there is a small clerical error on the affidavit of service at the face of it. It does say that service occurred on August 2nd of 2022, when it should say September 2nd of 2022. As such, I would ask that the record remain open for submission just of a clarifying affidavit of service reflecting the correct dates of the actual service performed.
Okay, and right, we'll address how the length of, depending on what goes on.
Exactly.
Length of open.
Yes.
Okay, thank you. Denise, you have a report?
Yes, I do. Eric?
Yep. Hopefully you can see that, although I apologize, the photos are somewhat shrunk, but
And they're out of order, but that's okay. It was properly posted. The photo, the affidavit of posting is in there somewhere. This is parking that's occurring right across the street from the front of the restaurant. It's actually by Mr. Perchek's house. Next. A little bit bigger. This is in front of the restaurant, which is facing southwest. These cars are parked all along Maidstone Park Road. This is the rear of, this is actually on Richardson Avenue. This pile of debris is just sitting there. There's actually other photos regarding this too. And that fence is relatively new. It's just gone up, and I'm sure it's been done without any kind of approval from ARB. This is again what the neighbors have to see. You drive by this, and this is debris, which I can only assume is being used for beach parties. This is again a shot of the front of the restaurant. This restaurant fronts 3 streets, Maidstone Park Road, Harbor Boulevard, and Richardson Avenue. And this is the section of Harbor Boulevard where the cars, park. They just park along. This is another shot of the same Harbor Boulevard.
same one.
This is the same one. This is actually, sometimes cars are even blocking the road because they're looking for parking spaces. This is the outside dining. Again, there's a fence erected, no ARB, lighting, no approval from any departments. There are 8 outside tables. One can only assume it could be 5 to 6 people at each table, which increases the capacity of the restaurant. Next, please. This is actually the notice. It was finally properly noticed. These tanks are on the Harbor Boulevard side. They're actually exposed. I could have literally picked one up and put it in my car. There's no kind of enclosure. They're not hidden from public, and they're just exposed, and they're just sitting there. This is again to the rear of the residence. Garbage gets collected back there. There's garbage there all the time. I mean, you can go there any time of day, every day, and it's just garbage. I don't know when it gets picked up. It's just another shot of the garbage bins. This at one time, this might be enclosed now, I'm not sure, but this is on the Harbor Boulevard side. This is just an area where things just get thrown. Same area. This is Richardson Avenue. Actually, it's relatively early in the evening, and it gets worse as the evening goes on. These are probably taken around 7 o'clock, maybe 7:15. This is Richardson Avenue as well. And this is, other than this restaurant, this is a residential area. This is again another view of the same thing. It's just a continuation of cars all the time once the restaurant opens. This is a problem often because when the restaurant gets deliveries, because there's really not any kind of loading or staging areas on the site, many times the deliveries are blocking the road. And as you can see right here, the postman is having to wait till everyone gets out of his way. Again, a shot of the outside dining. As you can see, there's propane lighting, and there are 8 tables. Just another perspective. I'm taking this from Harbor Boulevard. And behind it is the residence, which is actually a permitted use. This is that open area behind actually the outside dining area looks like this. And now that's where the propane tanks were stored as well on my last inspection. This is just the corner showing that this is the corner of Richardson and Harbor.
That's the last.
And I think that's it. Thank you, Eric.
Thank you.
You're welcome.
Do we have counsel representing, or do we have applicant with us this evening?
Counsel.
Okay, thank you.
Good evening, members of the board.
Good evening.
My name is James Lahadamas. I'm the attorney for Miller Brothers Hospitality LLC, the applicant hearing.
Okay, proceed.
So we appealed the decision of Ann Glennon, and the record reflected the original letter date. But to be clear, Ms. Glennon's original letter is dated August 17, 2021. And then due to the withdrawal of the first planning application by the property owner and then a resubmission, it triggered the interpretation to be needed again by the planning board. So then we have the March 28th, 2022 letter that indicates in the letter that we're reverting back to the interpretation of 8/17/2021. So I believe, in essence, the real appeal has to do with the information and language from August 17, 2021. And we believe that there are several inaccuracies within that determination that are grounds for appeal, both factually and from a legal perspective with respect to the definition of catering. I mean, I think that's why we're really here today, is that there is no clearly defined definition of catering in the East Hampton Code. There's references to it, but there is no clearly defined black and white, this is the definition of catering. So my clients, in preparation for use of this space, they did their due diligence, and it was their understanding that catering was an accessory use to a restaurant. So, and I say this without the most respect, I believe I need to make one clarification, because there seemed to be an inference when the pictures were being shown that there is a non-permitted use going on at the property.
In their assumption, did they go to the town's planning department to verify if those uses were allowed uses? Or did they just begin those uses in assumption? That might be why we're here this evening. So, I mean, we do have a very tight code regarding planning department, planning board applications and uses and allowances. And if they assumed something without going before them, that's my question. Did they do that?
Well, I would say no, because initially there wasn't, the planning aspect was triggered when there were physical changes to the property.
But there's an approved site plan, right? There's a site.
No, sir. That's the problem with this property, is that this property predates zoning and that there is no site plan.
Okay,
and what we're doing in planning right now, and that's something, sir, that's a key aspect of this. Because even when I first started and I got engaged in this case, we had a meeting, and everybody, at least initially, thought that there was a site plan that we could work off of and say, okay, we have a site plan, something was changed on the property, let's go back to planning. And in that investigation, we determined that there never was a site plan. If anything that's in the record, there's a survey in the record from many years ago.
A pre-existing non-conforming building does not allow one to change the non-conformity or increase non-conformities. Am I right? So even on a residential property, if it's something is pre-existing non-conforming, you just can't go and build a deck and say, "Oh, I didn't know it was pre-existing, and I'm entitled to do that." Is that correct?
I would say absolutely that's correct. And what we, where things, and what we've been dealing with in the justice court, and where we've been dealing with this with planning and building and everybody, is to determine what things were changed. And that's what we're dealing with in the planning department.
Still, the responsibility of the property owner is to know what's allowable and what's not allowable. It's a obligation of the property owner to know those things. So just to go and expand something, you can't use that as an excuse.
But sir, I would say we didn't expand anything. What we're in planning department for is the fence heights, the fence locations that were moved pursuant to the directives of the East Hampton Highway Department earlier this year. And the physical moving of a refrigeration system and the addition of on-site parking. So the only modification that was made to the property without approval was the moving of the refrigeration and the location of the fencing. I think the member of the board acknowledged that there was one photo where there was no enclosure on the Harbor Boulevard side.
I do want to pull this back too, and I apologize a little bit too. We do have a narrow scope this evening to look at that. So it's not us to really debate site plan and all that. I appreciate that.
I understand. So one of the things though, sir, is that why I believe and why my client believes we had to come here, we had no choice to come here, is again, more so along the lines of the definition, right? So if catering is an accessory use to a restaurant, and this location has a restaurant CO as a pre-existing, it is not a non-conforming use, because as we made clear and as we determined, we initially thought that this was a pre-existing non-conforming use. And then when we pull the records out, there is a certificate of occupancy for this property that includes the use of a restaurant and a residence. That's on the CO. So then we get to the point of this issue
But
with
may
catering.
I just stop you?
Yes, please.
Because what you just said defines 255, 245, which does define the number of uses. And in this case, you are absolutely correct. The two legal uses on this property are a restaurant and a residence. But Rita Cantina is clearly catering for off-site restaurants and businesses, which would represent additional uses, no?
Well, I believe that's one of the reasons why we're here.
Why we're here. So
Right.
can you address that? Can you cut to the chase and just tell me why this property is justification for 4 uses versus 2, which is what the code dictates?
Because our position is that, this is what everybody's doing. This is what Uber Eats does, right? So,
We're not here for Uber
Yeah,
Eats.
we
We're
don't
here
care
for
about
Rita Cantina. I want you to
Correct.
address this property.
yes, and I'm addressing this property.
Then answer my question.
With respect to it, our position is that the catering that's going on at the Rita Cantina location is permitted under the guise of catering is an accessory use to a restaurant. There is a restaurant certificate of occupancy, and it is our position that the catering that is going on at this establishment is the same type of catering that's going on throughout the town of East Hampton. And we believe that it is permitted because we have, the same ownership. We have the same people. We challenge this position that one of the letter says to 2021, August 17, 2001 letter says running their business. And I will tell this board that is not true, right? They do not run the catering business out of Rita Cantina. The catering business is run off-site at a separate location, separate storage, separate everything. However, what my clients do, and what's in our planning application and what's everywhere, is they go to the Rita Cantina location solely for the purposes of picking up prepared food.
So isn't that an intensity of use?
What's that?
That is an intensity of use. Now, you have, I think you asked one of the questions I was answered. One of the questions I was going to ask is, are there other locations for the businesses, Food & Co. and East Hampton Clam Bake?
Well, the locations for those two things, they're catering. So inherently, they're catering off-site, right? They don't cater on-site. So when you ask about other locations, do you mean the locations of where the food is served? That's an inherent fact of catering because they're either serving at beach locations for clam bakes or they're serving at private residences or private locations.
I think
But the storage of the items pursuant to the directive of the town attorney's office through various conferences last year, as of, I believe, sometime in the middle of the summer of 2021, there were no vehicles being stored, no catering vehicles being stored at the location, at the Rita Cantina.
So is your argument saying that the nexus for us for overturning the appeal, the building inspector's determination is because everybody's doing it?
No, sir, not at all. In fact, it's more so along the lines of where is the line? What we're trying to determine for now and in the future, right? Because if the town's position is that, this particular location is inherently improper for the operation of the restaurant, which it seems to be, the majority of the photos there have nothing to do with catering.
Do you know of another allowable use in the town of East Hampton where there's catering going on with locations, active business locations apart from the restaurant?
I don't understand that, sir. I'm sorry.
Well, you just said that Clam Bake and Food & Co. have locations apart from Rita Cantina location. Is that right?
Not Rita, right? Rita's on site.
Rita's on site.
Correct. But
the other two companies have locations. Do you know of
And by the
another
way-
restaurant of that situation that's allowed to have that use in the town of East Hampton?
so I need to correct the record with respect to the number of companies also, right? So as we said in our planning board narrative, there is only one company, right? So it's Miller Brothers Hospitality and then Sill Mill Catering. Those are the two. Food Co. and Clam Bake, they everybody continues to believe that they're separate. They're not. It's just two DBAs. So what we're dealing with is two companies, not four. So it's our position that, if there's an additional use.
How many DBAs would you be allowed to continue catering? How many DBAs would be allowable?
I mean, I don't see a preclusion in the town code with the number of DBAs, right? It's the number of, there's nothing in the town code that says a business can't have more than one DBA. So in this sense, it's one business with two DBAs is our position. And it's a legal fact, right?
I'm sorry, do you mean 3 DBAs or is Rita Cantina a DBA?
Rita Cantina is a DBA from Miller Brothers Hospitality. That is correct. So the LLC is Miller Brothers Hospitality. Rita Cantina is the DBA or the name of the.
And the other 2 are DBAs of
one company, Sill Mill Catered.
Sill Mill.
Correct.
Which are Food & Co. and Clam Bake?
Yes.
But they have other locations.
Storage. So we were told, we were
You
asked.
said the catering is being run out of different locations.
Well, one of the principles, as far as no money from Food Co. or Clam Bake gets transacted at Rita Cantina. No customers of Food Co. and Clam Bake ever come to Rita Cantina for the purposes of any type of catering.
Is there a contract between Rita Cantina and these other companies?
Frankly, no. They're owned by the same people.
Oh, so but they're DBAs, right? So how's the transaction go between? Is there any contract, any lease, anything?
I think what he's saying is when Rita prepares the food for the 2 catering companies, is there some legal basis for the relationship? How does money change hands between these 2 companies?
There is accounting between these 2 companies as far as the food is concerned, because Hampton Clam Bake and Food Co. does not buy any food.
And
Rita Cantina
and
buys all the
Rita
food.
is preparing the food for these catering.
Well, ma'am, that's
So
the
if
tough
they're
part.
No.
When you say
That's a
that,
question.
yeah, but I can't answer it.
Go ahead.
Because the problem is, like, the gentleman, Eric Miller, he's Eric Miller. He's the chef for both. So when you say, is Rita cooking for Food Co. and Clam Bake, or I can't answer that because it's the same human being.
But there's 2 separate menus.
They're
They're not the same menu.
Yeah, but there's
We'll
overlap.
look them up for the 3 different people involved.
Mhm.
So if Rita Cantina is preparing the food for these other catering services, how does that not constitute an additional use?
Because again, catering is a permitted use to a restaurant, and all they're doing is catering out of a restaurant. The fact that it is a separate company owned by the same individuals is where we do not believe that qualifies as a separate.
How
and
many
distinct use.
catering vehicles are used in this operation?
4, I believe. 4
And
trucks.
where are they stored?
Where are they stored?
They're owned by the
No, where are they
employees.
stored?
Where are they
Where are they
parked?
parked at night?
They're storage. Yes.
Where's stored at Rita Cantina's location?
No.
Where?
We haven't stored any trucks or trailers at the Rita Cantina location in over 1 year. And that was pursuant to,
Well, when I did field inspection photos, they must have just been there to say hi to everybody because they were there.
I can tell you for a fact that they haven't been stored there. And, that was even pursuant to an agreement that we made with the East Hampton Town Attorney's Office last summer, where we had a conversation, a conference, and we had an agreement that no vehicles were going to be stored there. So no catering vehicles are stored at the Rita Cantina location. The only thing they do
So
is
what
come-
is the basis of that agreement with the town?
The basis of that agreement was the site plan aspect of it, that we didn't have site plan approval for on-site parking. Even though the East Hampton Town Code provides that, every commercial property, could have on-site parking with this, because this predates zoning, it didn't have a designated on-site parking area. It had this driveway. If you saw the pictures before the fence was put up on the Harbor Boulevard side, it was open. So it was a driveway that was usable. It just wasn't on a site plan because there was no site plan that existed. So that's another aspect of the site plan. So, I mean, whether you call it a change or not, the only thing they did was put, gravel down, or dirt and gravel, and redid the grade there, but there's no asphalt or anything like that there. So that was the place that the trailers and the trucks were being stored. And then again, after review of the code and conference with the town attorney's office, we agreed.
And that goes back to my original question to you.
Sure.
Doing things with a homeowner or property owner or anything, doing things, whether it's pre-existing or not, if you're changing something, you need to go to the town. Going to the town later and getting slapped on the wrist is not the way to go about it.
And I agree, sir. And sir, I got retained on this matter. I was initially handling the town code matters, and obviously I've explained to my clients I can only fix from when I got retained moving forward. Anything that happened before then, I've advised my clients accordingly with respect to their what happened. And again, I believe that we've been cooperating and working well with the town of East Hampton for well over a year now, because we started in the Justice Court in May of 2021. We, obviously you're aware of our planning application. And obviously now we're here with respect to, this matter. And I agree, sir, that, and I've advised my clients, these things can't be done without approval. And that's why since that date, since I've been involved in the matter, we're doing everything in our power to communicate with the town so that, anything that occurs there is not, impacting negatively the community.
But you have a highly constrained lot.
We agree with
It's
that.
a highly constrained lot in a residential neighborhood. So this increase in intensity or whatever, I mean, that's the planning department's purview. It's not ours right tonight, but it's still, it needs to be said.
But sir, I would respectfully submit to this board that catering does not increase any usage aspect, right? Because the parking problem that's there is an inherent parking problem to the location. Whether they cater out of that location or not, the parking problem is going to deal with the patrons that are going there for the 76 seats that they're limited to.
But I don't think the pre-existing use of this property was doing catering businesses for other businesses.
And I agree with you. And
there's a septic system there that is outdated.
Mhm.
and it's being overtaxed. There's a definite increase in intensity on this property because it wasn't being done before.
And I submit to this board that the reason why the place is busier now, because it's got some good operators that produce good food, and people of the community are patronizing the establishment, but they're not going there. They're not patronizing. They're not parking there because of catering.
Whether or not there's an occupancy for a particular property of such and such, you can't say that catering, it doesn't have any extra impact on intensity. You have an occupancy, you fill the occupancy, you can't go beyond it. So whether it was good or before or good now, you still have an occupancy number.
Correct. And we're not exceeding that occupancy number. That occupancy number is not impacted by catering.
Because my point is, if you have 76 people that are allowed inside the restaurant,
Mhm.
are you cutting that in half to the 40 additional that are outside, or is that an additional 40 to the 76 that are already in the restaurant?
No, the way it
That would
works
increase
is,
parking.
yeah, we have an application right now. So the boards, I'm sure aware, is that East Hampton created a new outdoor seating plan. We have that
I
outdoor
know,
seating
but my
application. in.
question is,
There's a
are you-
corresponding reduction in interior seating for
so
exterior.
you're not having 76 people occupy the inside of the restaurant because you're taking that number in half and putting it outside.
I don't know if it's half, but again,
Well,
any seating.
If
So
it's 76 inside and another 40 outside, that's a potential for 120 cars. So and even if you split that
that's
in
not the way
half.
it works.
You're allowed to exceed the given occupancy.
so what happens is,
So my question is the restaurant adhering to the 76 inside? Or are they taking, whatever capacity you have outside, deducting that from 76?
I could say this, it's a 1-for-1 deduction. So for every 1 seat we put outside, we remove 1 seat from the interior.
Let me ask you a different question. If your existing use was to serve 76 people within a certain number of hours over turn, and you then start serving an additional 50 people through catering, and then an additional 100 people through catering, where are we supposed to come up with a line, if we are, that there's an increase in intensity of use? Just because a restaurant is allowed to do catering, at what point does the catering exceed the seated capacity that you were previously serving? I mean,
I understand her.
and
question.
maybe the code is, maybe it's just that the code is ambiguous and the code needs to be amended.
The code is, it's our position that the code is ambiguous, at least with respect to this. And in the sense that there is, no definition for us to rely on. As a hypothetical, one of the problems we have here is, so in the event my client said this location is not suitable for us, we have to move to another location. We don't know what the rules are now to investigate another location, right? Because we have this amorphous definition, or like the board member said, we don't have a clear-cut line as to when.
I think you do. I think you do have a clear-cut line. I don't think the code is ambiguous. I think it's telling you can have 76 people on this site.
I think
And there's no argument about that, ma'am.
And the intensity, there is a nexus to this, because if you put more people outside, the nexus to that is increasing the area with parking catastrophes, which everybody is suffering in the community. There's always been a restaurant there. We've never gone through this before, but they've always just operated as a restaurant. There hasn't been outside catering services. So there is a nexus to the number inside and the number outside.
But this is no longer a pre-existing non-conforming use. And that's a key thing. So I was retained in May of 2021, and it wasn't until October 2021, because we all analyzed this as a pre-existing non-conforming use, as if the zoning did not allow for this. But we are aware that this particular property is zoned neighborhood business. Therefore, this is a permitted use. So the analysis of expansion of a pre-existing non-conforming use is not the analysis. I respectfully submit to the board, because we have a certificate of occupancy that says restaurant, and we have zoning, current to-date zoning, that says neighborhood business. So the analysis respectfully is not whether we expanded a pre-existing non-conforming use. We didn't do that. We have a current existing use of a restaurant. The question then becomes, does the catering that my client is doing, does that exceed the scope of accessory catering? Or is it accessory catering, which it's been unquestioned in the town of East Hampton, is permitted if you have a restaurant CO? And there's no definition in the code that provides us, okay, accessory catering. Accessory catering is this. We don't have that in the code. So that's why we believe we needed to appeal the decision for more clarity and to understand, okay, moving forward, how do we operate this? Or if we have a restaurant, can we use Uber Eats, right? Because Uber Eats is coming to my restaurant and taking my food and delivering it to members of the community. Well, now is an Uber Eats and whatever restaurant they picked up from, aren't they now operating an illegal catering operation pursuant to this definition? I would submit to the board that they would. So I think there's a modern trend in food that's developed from COVID with respect to Uber Eats and, off-site deliveries and all these things that I would respectfully submit to the board. The board needs to consider when we're talking about definitions, because I agree with you, ma'am, that this business has been there for 50 years as a restaurant.
Longer than that.
Yeah, more than that, right?
Yes.
Judge Rana was telling us the stories about how she used to go there as a child and stuff. So,
Only open on the weekend.
but how is the restaurant model and the business, how is it developing, right? How is it, what direction is it going in the future? So we have an establishment here with an unquestioned CO for restaurant. And we're just saying that we believe our catering operations do not exceed accessory, and that we're the equivalent of how all the other restaurants that are allowed to operate the way they operate. Our position is that the only difference is a name. The
But if the other
humans,
ca-
the people,
There
everything
is,
behind
there,
it is the same.
there is a threshold, if you will.
Yes,
And that's what I think why we're here tonight is to establish that, to whether that threshold is there or not.
correct. And I think
Right.
that's where the threshold is not necessarily defined to the point
Right, but
where I can tell my clients, you can do this or you can't.
I'm leading up to a question.
Sure.
We have in the pictures tonight, we had a big pile of logs on the thing. What are those logs used for?
Firewood.
Well, where?
It's offsite and onsite?
All right, so that is clearly a town unintended intensity of use on that property. So where is that threshold? And that's why we're here today. That is evidence to me that that's exceeding the intended use of that property.
Well, council, we're here today, right, because of the two uses that are granted to you on the town code, right? As far as having your residential use and your restaurant use.
Yes.
So just going through that line of thinking and to clarify the line, you have Rita Cantina is your restaurant that's on the property.
Correct.
They're the ones that use the seating. There is no catering company or outside catering or an extension of Rita Cantina that uses the seating on the property.
I'm sorry. My client understood that question better than I did.
So what essentially I'm saying is that the catering companies that come in, your indication today on the record was that they are there only for the sole purpose of picking up food
Correct.
and then leaving the property.
Correct.
So we're back to this. So then Rita Cantina is the restaurant in name are they also the restaurant on name on the lease agreement, or is the lease agreement under Miller Brothers?
No, Miller Brothers is the restaurant.
Miller Brothers is who's on the lease.
So Miller Brothers Hospitality is the one who's on the lease and
Okay.
who has a liquor license from the state of New York. And that's Miller Brothers Hospitality LLC.
Mhm.
And then catering is Sill Mill Catering LLC,
And
does-
Sill Mill has two
DBA names.
DBA.
Does Sill Mill have its own liquor license?
No, it doesn't need one.
I want to ask a question here, getting back to Ann Glennon's interpretation of the situation as it exists at this time.
Yes, sir.
And that is that if I were to come to Rita Cantina and said, I'm going to run a catering business, and maybe you could prepare it in your fine dining room, a fine kitchen, and I'm going to distribute it around, would we be in a position where we would consider that an additional use? We're being asked that question, right? Are we playing a little bit of legal semantics here by saying, well, it really isn't an outside company because we own it? Okay, that's what you're saying. And that may be in a way, then we get asked, is that really a way to evade what is basically the intent of the town to make sure we have single use on the, two uses on the property because of the residents. But in terms of the scope of what the restaurant is allowed. So now we're going to do that. If I came to them and they said, well, we can't do that, but if you want to put your DBA and become under our umbrella, we could do it more. There is, as was mentioned by the chair, there's got to be some point where it's saturation. And are we just, or are you or Miller Brothers in this situation avoiding what would be a confrontation over outside catering companies working with them by just putting them under their umbrella. We have to go back because that's part of what Ann Glennon ruled on. That's part of what she said, that this is an extended use that goes beyond the intent of the zoning. I have a second question, and that is that I know that in September of last year, you had an application in for site plan. We're not here to discuss site plan, but site plan, and then it was withdrawn. Part of the problem I know for the community and the neighbors has been parking and congestion. We saw that in some of the photos. I'm just wondering why, if we wanted to get this thing to move forward and in most hospitable way with the community, why not push forward with that site plan? That would have come in front of the planning board and possibly in front of us if we had to make a decision. And that would have helped clarify what's happening with 4 catering trucks. Now, you say they sleep off site. You're on their own, so I'm sure it's true. However, a board member did see them there during the day, and I imagine that adds to the congestion for the entire community. So a long question just to say, are we playing a little semantics here saying, well, you're not really an outside company. It's all under one umbrella. Okay, that's just a way to avoid the real problem. And that is the elephant in the room is that we have a congestion problem in this community that has exacerbated and become much larger than it was under the 50 years or so that's been testified that the restaurant's been open. This is a real problem. We go back to the determination of the building inspector here, and that's what we're going to concentrate on. All the other issues are issues. They're not in front of us, however. Right? But what is in front of us is are we being made slight of by saying we're really just one company, but in point of fact, you're not. There's more than that going on here, and we have to determine whether that's what we're going to be ruling on today, right? So
Sir,
what are we doing here? What are you doing here? What are Miller Brothers doing here in terms of presentation to us saying it's one company? Again, we could add 9 DBAs. Let's go to 12. Why don't we go to 20? We can get everybody in town coming to one place because their food is so excellent. There's a limitation here, and our interpretation is going to be based on what we see as that limitation, what that limitation should be.
understood.
Okay. You understand it, but I'm going to tell you that's going to be at the heart of what I'm going to be thinking about as we move forward on this case.
I don't want to sell this, I don't want the board to believe that I'm trying to make an inference that, that, oh, it's just one company. Let's not worry about this. That's not our position at all. And that's the reason why we've been, from the outset of our planning board application, forthcoming with respect to the legal operations and how they work. The reason for the separation of the entities is solely a legal one, right? I mean, it's a division of liability, right? It's a protection, of the businesses, right? That's a matter of practice, not designed specifically for us to come here and say, oh, but it's still one company because it's owned by the same parties. I don't want the board to believe that I am submitting to you that, let's not look at this because it's really one company with the same people. I am on the other side, on the definition side of, the restaurant aspect of it, that the definition has been, it's not solely attributed to the separation of the company. The belief is that the type or the volume of catering operations exceeds what is allowable under the accessory catering of a restaurant, but we don't have a definition of when you are exceeding it or are you not. So for example,
we do have a definition. We have we have a definition of 50 years or more of a restaurant existing there in a community, in a very small community, on a very constrained property. That is a definition, and this definition appears to have increased intensity greatly. So you can't say we don't have a definition. We do. It's pre-existing non-conforming use or whatever, but it's the intensity appears to be storing a big thing on logs on a property for outside use. It's not intended for that.
Again, our position is that it is not an analysis of pre-existing non-conforming, so we don't have to review the previous 50-year history to determine whether or not what we're doing now is permissible, because the zoning is neighborhood business. And we do have the restaurant CO. So, I respectfully, we started doing that analysis. I mean, on our first meetings with the building department, with the town attorney's office from about May of 2021 till I think October or November when we had a meeting, everybody believed there was a pre-existing non-conforming. So I understand that. And one of the questions of the other board members was, the length of time that elapsed between, the initial violations and the submission of the planning department. And again, I wasn't retained on the initial planning board application. So respectfully, I can't comment on what happened, prior to that. There is a property owner and a tenant here, and, there was a submission by the property owner. So I can't comment on what happened there before. I do know that once I did get involved, I believe we've been, doing our best to get to the bottom of it. But there was a period of time where the analysis of what we had to do had changed significantly because, sir, we did the same thing as you did. I did it myself as an attorney. I said, we have a pre-existing non-conforming use because that's what we were told.
I'll still apply what I said, whether even on the zoning application on this property, right? The zoning definition on the property. We have a restaurant there for over 50 years operating in a certain way in a community where it was coexistent in a residential neighborhood. And now we have a clear increase in use. So whether it's pre-existing non-conforming or a specific zoning use, it still has changed.
I would submit to the board, though, that if it's not a pre-existing non-conforming and it is a permissive use,
I get
right?
it.
The analysis.
We're going round and round, and I think we should try to pull this back together. Like, just say, let's move on because we do have other hearings this evening. I don't want to keep, going.
I
in
understand.
circles.
I'm only
So-
trying to answer. I don't want to,
I get it.
go in a circular. I just want to make sure I've answered all the questions,
Okay.
to the members of the board.
Any other
Well,
board members? have
Yeah,
any questions?
I have
Okay,
something I
Terry has
want to
some
say.
questions.
Yeah. Okay, so you were retained in May of 2021. You got the letter from the building inspector August 17th of 2021, or the owner got that. And then you had these meetings, you say, in October and September, and then the application was withdrawn when?
The application was withdrawn right before that. And then we had to have a meeting to understand exactly what we were doing. Obviously, dealing with interdepartmental, we have, justice court, we have the town attorney's office, the building department. At the time, we had the highway department. So it was just a matter of making sure we were all on the same page. I believe at that time, the previous application had been withdrawn.
Before that meeting?
Correct, yes.
Okay. Now, there is a definition of a catered affair in the town code that says a private gathering of people at a restaurant. What you're talking about, what they're doing is not a private gathering at a restaurant.
Correct. So we're not even talking about catered affair because we believe that the catering operations, because they're not on site, the catered affair definition would be inapplicable.
But you think the use would be. Okay, now Uber Eats. I don't use Uber Eats, but if I call up Uber Eats or go online to Uber Eats and I want to order something from Rita Cantina, can I order anything that is not included on the Rita Cantina menu?
I don't know if we're involved in Uber Eats. So
We do not use Uber.
Oh, okay,
Yes,
so
yes.
Uber Eats is irrelevant here. Okay, all right.
correct. Yeah. So Uber Eats is a separate company that essentially sells your food to somebody else. So they come and they pick up your food, you buy it from Uber Eats, they come to your restaurant, they pick up your food that you prepared, and then they sell your food to someone else.
How many
Yeah,
menus
I
are
get
being
that,
used
but you use them as an example.
between
Yes.
So that's
Rita?
irrelevant in this
I'm sorry.
case.
I'm sorry, ma'am?
That statement that you made is really irrelevant in this because they're not doing that. Rita Cantina is not doing that.
Correct. But we believe it's important with respect to the definition of accessory catering with respect to moving forward, especially in a modern day where Uber Eats is a multi-billion-dollar industry that operates, everywhere throughout the country. And there's no regulation on them whatsoever. But here we have a, mom and pop operation and their activities are being reviewed with respect to the definition in the code. So I only reference Uber Eats with respect to they're operating, and it's our position we submit that they're essentially doing the same thing. So the definition, if the town of East Hampton wants to allow Uber Eats to operate, then we need a more clear definition so that everybody else can understand what they're doing differently than, other companies that are doing it that are not having the same issues as we are.
Okay, from what I'm hearing, it is a mom and pop and it's a restaurant and it does need to conform to this code and all that other discussion. Maybe that's a future, but it doesn't exist today. The definitions exist today, and for that business, they need to conform to those definitions.
Yes.
Between Rita, Food & Co. and Clambake, how many menus are there?
I think we submitted these.
Yes.
There's one menu.
He should be under oath if he's going to speak, so.
Yes,
yeah.
I can bring them up.
Yeah,
I'd be more than
yeah.
happy to put them under oath. Yeah, please. State your name and address for the record.
Adam Miller, 28 Maidstone Park Road.
Okay, Adam, do you swear affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, sir, I do.
Thank you.
I'm sorry, remind me of the
Said
question. I got it.
Number
Yeah,
of minutes.
How many
I got
menus
nervous walking
between the three? How many menus?
Well, Rita Cantina has one menu, which you can find on our website. Hampton Clambake has one menu. On the Rita menu, we do serve the Hampton Clambake. So those menus do overlap with each other. And Food & Company is a pick your own poison at-home catering company.
And the preparation of this food is done at Rita Cantina.
The preparation for Clambake is done off-site. So our Clambake business, our trailers, we had trailers on site when we opened. We were told by the town of East Hampton, please move your trailers. We were able to figure out with where our storage unit was to then said move trailers. I don't know what the date of of when you saw the trailer on site was, but I know I live on the property.
I've seen. it
I'm the
numerous
mixed
times.
use guy who lives in the middle, and I know for a fact that the trailers have not been on the property since I called Charles, who is with the codes board. Anytime we're going to do anything, if we're going to change a light bulb, we text Charles, and we've got updates on all that. So I know that the trailers have not been on property. I just wanted to,
Getting back on point. sir.
I just wanted to make that
Food and
clear from
Company
before.
menus, where are they prepared?
Come again?
Food and Company, where does the other catering? Where is
Food
that?
and Company, Rita
So
purchases.
what food other than Rita Cantina is prepared on your site?
The food is prepared for
Okay,
Food and
that's the-
Company
that's what I'm asking you.
at Rita Cantina, correct?
Okay.
Yes. The same way food is prepared for riders or for
No, no, no.
rancheros
Just talking
at
about Rita
Pepperoni's,
Cantina, right?
right? Which is 3 different operations operating out of the same use, one of which
I
has
just
no
want to
brick and
stick to
mortar.
the issue,
And it's
which
just a
is
ghost kitchen running
before us
out
tonight,
on
is the
Uber Eats.
number of uses.
I understand.
And the number of uses, according to the code right now, is Rita Cantina, the restaurant is legal, and the residence is legal. And these 2 additional uses.
Let's move on.
Because they're
Let's move
off-site.
on.
Okay.
Yeah.
One clarification that I don't know if it was
I'd like to
heard.
hear from Eric.
Food code does not have a menu.
There's no menu.
Does not set menu. So if you can call up Food Co. and you can ask for anything you want, whether it's on the Rita menu, whether it's on a Clambake menu. Food Co. is designed to be your own menu. So you contact Food Co. and I want this food. They'll make you whatever you want. It's not on a menu. It's not limited.
No,
it's not
my
designed.
question was not that. My
Okay,
question
we
is,
get it.
where is it prepared?
Understood.
Okay, let's move on. Thank you.
Sure.
Anybody have any questions? Sarah, did you have any more questions?
Terry,
Not at this
I'd like
time.
to hear from Eric.
I actually have one thing I want to say, and that is, are you familiar with the TAM that was issued relative to this application?
I'm sorry.
The technical analysis memorandum?
Yes, in the
You're
planning
familiar,
department.
right.
Absolutely.
So
Yes.
on page 2 of that midway down, the zoning board of appeals should take note. That begins a paragraph. And in that, it mentions that there is an option for a business owner to appeal the planning board for a multiple business complex usage. And under 255-11-10, an application can be made, and you could have come forward and said, we're looking to do more than what we're doing. And that could have been reviewed under that code, possibly coming to us, possibly going to the planning department. That's an option, rather than come in here and look to get this somehow approved without a real vetting of all the information. This is part of what we're facing here tonight. I
Sir,
just wanted
I
to
do
point
not-
that out, and you should be aware of that. If you're not, it's in there and it's clearly explained the mechanism by which you can approach the town for additional usages on a property. And there is a mechanism by which you can apply for that.
But the reason why we're here tonight is to decide that.
Right.
We're not trying to thwart that application process. We're well aware of it, and I believe you're well aware that since, I believe, April now, in planning, we have to address the septic system issue, which we've been doing for quite some time now. So before we can get to any additional uses, we would have to address the site itself. So that's why, we're well aware of it, and I thank you for letting us know that.
And what is the
that's
status
something
of
we may
that?
explore. I'm sorry?
What is the status of that in front of the planning board?
We have a submission due in 6 days. So we have our septic system, our proposed septic system site plan to submit. That still requires health department approval, but we're making progress.
Right. I want to move on to the planning department's presentation now.
Yes.
Thank you.
Will I come back up?
You'll be able to come back, sure.
Okay. Thank you.
Hi, Eric Shantz for the planning department. I think you have to swear me in. Or?
Yes, Eric, do you swear affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
I'd just like to quickly, and I need to sit down here to show you some visuals, but give you a very brief background just of how the question of the number of uses came up. And I have 2 visuals that'll help you see that. Obviously, what you're looking at on the screen right now is the aerial photograph of the property. If I can get it there. What I want to show you is the survey attached to the most recent CO, which is from 2005. So just let me adjust the visual here a little bit. And I apologize that this is also a little bit difficult to see, but I'll share screen right now. So now you can see that is the survey attached to the CO. Mr. Vlahodimus is correct. There is no pre-existing site plan approved for this property, but basically, as you can see, most of the property is taken up by the building. What you see on the west here, or the left-hand side, basically there was a fence that ran through that area, but there were no other structures or improvements. So what I want to do is then just quickly jump back to that aerial photograph, just to show you the comparison. And this is an aerial photograph that was taken in the spring of 2021. So now you can see that all of those structures you can see there, obviously, none of them obtained site plan approval. Any new structure on this property requires that. But one of the other points of interest here is if you look across Maidstone Park Road to that neighboring residential property, you'll see 3 rectangles as they appear. Those were catering trailers that had the Food & Co. logo on them. So when this was submitted for a site plan, that became an obvious question. How many uses are on this property, and are these outside uses? So the planning board, in keeping with usual procedure, asked the building inspector, how many uses does this constitute, after the applicants provided a narrative about their operations. So basically, the building inspector, as you know, it's in the determination, said that 2 additional principal uses had been added to this site. Again, there are 2 pre-existing uses, principal uses. That's the single-family residence and the restaurant. Member Johan made mention to what we mentioned in our technical analysis, one of the things, which is the multiple business complex. Every property is permitted, every commercial property is permitted 2 principal uses as a matter of right. So in this case, legally pre-existing was a restaurant and a single family residence. They can apply for a multiple business complex special permit approval from the planning board to get more than 2 uses. However, you cannot exceed the, there's a lot area requirement per use in the town code. That's in 255-1110, the dimensional regulations, that limits in the neighborhood business zoning district, you need 10,000 square feet per business. So in other words, you could have 2 as a matter of right. And then if you had, let's say, 30,000 square feet of lot area, you could apply and you'd still need to meet the special permit standards, but in theory, you have the yield for 3 uses. This lot is under 7,000 square feet, so it is less than what would be required for 1 use, even though, again, the code does say that each individual single and separate lot is entitled to uses. So I want to make that distinction first. And then also something, and I apologize that this is somewhat new to the record because it wasn't in our analysis, but just in hearing the conversation today and the presentation, another thing I'd like to point out is that 255-11-45 are the parking requirements of the town code. The parking requirement, so, there's a question here, getting back to the central question of whether or not the catering is accessory or whether or not those other businesses represent principal uses. Putting that aside for a second, and relating to the intensity of use, if not the number of uses, the parking requirement for a restaurant is 1 per 3 permanent seats. Now, the applicants are not proposing as part of their site plan or here to increase the seating, but that's not where the parking requirement stops. It's 1 per 3 permanent seats or 1 per employee. So if you are, and again, the CO here, the last time the CO was issued, there was a restaurant, I believe it was called Michael's. They did not operate multiple catering businesses out of this location. You could definitely, I think, make a very strong argument that adding a number of businesses adds the number of employees and therefore increases the parking requirement, which is another trigger of site plan, requiring site plan approval. But really the central issue here is the number of principal uses. That was the determination. I will point out, as we did in the analysis, we completely agree with the building inspector's determination, but it was said here tonight on the record that to give you the numbers, so there's a single family residence, that's 1 use, I don't think that's in question. There's 2 LLCs operating out of here, and between those 2 LLCs, there are 3 businesses. So Miller Brothers LLC does business as Rita Cantina. Sill Mill Catering LLC does business as East Hampton Clam Bake and Food & Co. So, to us, the reality here, it's not even open to interpretation. It was submitted to the record that there's 2 LLCs and 3 businesses along with a single family residence. I think that it's pretty clear. I could read you the intentions of requiring site plan, which any increase in on-site parking requirements. Again, this property is legally pre-existing non-conforming at 0 on-site parking spaces. Any trigger to increasing the need for parking or any additional use, principal use on the property would also trigger site plan approval. We feel that is the case here, which is represented in our analysis. And I think actually backed up by, some of the statements that counsel for the applicants has made this evening. So that really, I think, is cutting to the chase of the situation here. And if the zoning board has any questions for me, whether it be pointed directly at the question of the number of uses or about the history of the site plan application or the process to this point, I'd be happy to answer them.
One question that I have is, are there any other businesses or restaurants in the town of East Hampton with multiple allowed multiple catering businesses of this that fits into this category?
Not to my knowledge, and it would be my assumption that if they were ever to come in for site plan approval, that we would treat that situation exactly the same as we have this application, in that they are separate additional principal uses on the property.
Okay.
What if they were all under one LLC or one corporation? How would we resolve the problem then?
I think the heart of the building inspector's determination is really the difference between a principal use and an accessory use. There are many businesses that are either restaurants or takeout food as defined in the code that offer a catering service or offer delivery of food. So long as that is accessory and ancillary and immediately subordinate to the on-site business and use, that we would deem to be accessory, and that has in the past been deemed by the town to be a permitted activity that's done in association with a lot of such principal uses. So I don't think that to me, although this may be a legal question, I don't think that whether or not it's 2 LLCs or 1 LLC, as Member Johan said, 3 DBAs or 9 or more, I don't think that would impact the determination. I think once you have more than one business operating, out of one location, you've added a principal use.
Good. Questions for?
I'm good, thank you.
I'm good. That was my question.
I'm good.
Okay, thank you. I'd like to pull up Ann. Ann, would you come up, please?
Good evening, Ann
Hi.
Glennon,
Do you
Principal
swear,
Building Inspector.
you swear affirm to tell the truth, the whole truth, and nothing but the
I
truth?
do.
Okay. Want to give us some background? What you,
Sure.
how you see it?
One of the things I'd like to clear up that's been thrown around a little bit, they are correct. The restaurant is not pre-existing non-conforming. I've never been confused about that. It's been there. It's a neighborhood business. The building is pre-existing non-conforming.
Got it.
That is where everybody's getting a little bit mixed up with that. It was brought to me from the planning department and from some letters that came in about how many uses. That's how it started. And that's when I originally got involved. I knew there was a residence and I knew there was a restaurant. And there were already 2 uses. So I felt any use over that would need to go to planning board to get additional uses if they could. That would be their only option. Basically, after reviewing and seeing that they were different businesses and different foods from what was being served in the restaurant at the time when they first came to me the very first time, most restaurants, if they're going to cater something, they're catering the food they're serving in their restaurant. They're not making special menus for that. And 90% of the time they're using most of the people that are in the restaurant, maybe additional few others, but where this was different foods other than what was being served at the restaurant, different company names that have been known in East Hampton town to have been businesses because around town in different areas over the time. So it was an interpretation that it already had the 2 uses, the 2 additional businesses with different foods was 2 additional uses to the business. And at that time, I didn't know if it was all under one corporation, one LLC. None of that was ever brought up or.
And that's a difference between a principal use and an ancillary or accessory use. Right?
We've always interpreted that the accessory use was, yes, it's the same, you're serving the same thing that's in that restaurant. So nobody was going to dispute if they went and did a party based off of the food they're already serving in their restaurant.
Now, you've been in the building department a very long time, right?
30 years,
Has that interpretation ever been different in your tenure?
never that I knew of.
Okay, thank you.
You're welcome. Any other questions?
Do we have any examples that come to mind of anybody who might even be getting close to this? I mean, other restaurants have pick up food and that's basically as far as it goes. And there's some catering done with their menu, basically. But we don't have anybody else in town who's
I've
doing
never
anything.
run into where, most of the restaurants that even might do catering, it's never been to the intensity this is, but all that aside, we've never run into where it's been multiple businesses that I know of in the time I've been in the building department. No.
Thank you.
Any questions?
Oh, good.
Thank you, Ann.
Can I clarify something very
Sure.
briefly? Very briefly, just to what I was saying before. I think I made it sound like the applicants could not apply for a multiple business complex. That's not the case. They don't have the requisite yield for more than 2 uses under the town code, really 1 or more than 1. But that is an avenue that they could go down rather than submit this appeal. They could accept that these were deemed additional principal uses and apply for the multiple business complex special permit from the planning board. Obviously, with that yield requirement, it would require an area variance from this board, but that is an alternative avenue that they could go down.
Okay.
Now, we're going to now go to the public part of this hearing. And I'm going to ask if you want to come up and speak, you identify yourself. You'll need to be sworn in, and you're going to have a limit of 3 minutes to speak. We'd ask you to limit your conversations to what we're here tonight is that the use. And so who here from the public is here to speak? Come on up.
Hello.
Your
Good
name
evening.
and address?
My name's Alex DeGiulio. I live at 22 Maidstone Park in Springs.
Okay, you raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
I just wanted to quickly give my input, being a neighbor that lives just 2 doors down from the restaurant, and comment a little bit about some of my experience in the food industry. Additionally, I feel like I have noticed that the catering trucks are no longer on the property, if that was an issue, but I get that a big part of the conversation here is about the uses of the space being an outside, having multiple businesses. I've worked in the restaurant industry for a long time and have a lot of friends that own food businesses in East Hampton. I think that there should be a little bit more conversation with other members of the community, perhaps, about how they run their businesses and catering companies, because it is actually quite a common, to my understanding, use for other members of the community to have catering arms to their restaurant. And perhaps maybe like a part of the conversation here is logistics of, as you mentioned before, the name of the businesses. That perhaps would this be an issue if everything was called Rita? If all businesses were just called Rita and they were still catering, would that be as much of an issue of multiple uses here? That to me seems like, I know several other people that have businesses here and everything's called the same thing, but they still are able to have a catering arm. Nobody brought up any other businesses that run that. I'm not here to do that today, just for fear of anything else, but I do have a lot of friends that operate in similar ways. And I think that that isn't necessarily something that's bad for the community or affects parking or congestion on the road. I understand this is specifically a referendum about multiple uses on the property, but there's been a lot of conversation about issues in the neighborhood and historic thing. I lived in the neighborhood before when it was Michael's, and then it was Almare or something for a season. What?
Backlander.
Right. So, and now it's Rita. Personally, big fan of the restaurant, which is why I wanted to come today and just say that as someone that lives on the block, I do feel like, yes, there is more people parking around town, but I don't feel like a catering company has anything to do with that whatsoever. I think that it's really a separate use that they're able to do out of their kitchens, but that if this is also a conversation about volume of people in the town or in the neighborhood, I don't see that being something that specifically affects me in my experience, living on the same side of the street as the restaurant, just 3 doors down. That's all I wanted to say. Thank you very much.
Thank you. Anybody else? Come on up.
My name is Stephen Walsh. I live in Maidstone Park.
Do you swear affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
I first went to Maidstone Park in 1950 when I was 10. My parents had a house built in 1952 on Bruce Lane. 86 Richardson Avenue, which is the house directly behind the restaurant, and 82 and 84, the 2 cottages next to it, are mine. I lived in 86 for 30 years. I've lived full-time in Maidstone Park for 56 years. I still own 32 Bruce Lane. I was there when it was the general store. I remember it. The general store had a couple of tables and they had a soda fountain. Your mail was delivered there. You could pick it up. I've dealt with the restaurants who have been there up until now and never had a problem or anything so minor that I could talk to the person and it'd be resolved. I can't even remember any. This place here is being used by 3 outfits. But one thing, after they take the food away, first of all, they cook the food there. So all the food has to be delivered there. All the pots and pans and everything have to be cleaned there. All the equipment that is used to take it out and serve it up out on the road and then has to come back and be cleaned there. If you go by in the daytime, you'll see the big pots and stuff like that that are part of the catering. If you look at this survey, in the front of the building on Maidstone Park Road, they actually own 4 inches. All the parking in the front of the building is illegal because you're not allowed to park in East Hampton on an angle. And the last time I looked, this was a 90-degree angle. To go back into the uses again. After the food goes out, comes back, the dirty pots and pans come back, then the garbage comes back. I was walking by there the other day, and there's one of the, the catering trucks. And the garbage truck is there, and he's loading up the garbage truck. So they store their garbage there, they store their food there, they prepare their food there, they bring the pots and pans back to clean the place. The parking is illegal in the front. Some of the septic systems are on the road. And if you look at the survey that's on the screen, you see a little bump out on Richardson Avenue. That's a stockade fence, and it's used to supposedly hide the garbage. I'm sorry, I'm laughing. The garbage there is absolutely atrocious. And of course, everything from the parties, the catering, comes back. The stairs on the emergency exit are on the shoulder of the road. The garbage there, I mean, you went by, you saw, it looked pretty when you were there. It is horrible. I've lived across the street from it. In 86 Richardson Avenue, I walk out, I would walk out my front door, boom, there it is. The other people could run a restaurant there for the 30 years that I lived there and for the 20 years that I walked by it almost every day. And we never had this problem with the garbage.
I'm going to ask you to wrap, if you could wrap it up.
Okay.
Okay, thank you.
Have the town buy it and get them out of there. Okay.
Thank you.
Otherwise, just get them out.
Thank you. Anybody else?
Hi, my name's Michael Fix. I live at Fanning Avenue.
Do you swear affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay.
My family has owned the house there since '73. So we've known Fat Flounder. We knew Michael's and beloved of ours. We went there all the time, knew all the people who worked there, et cetera. And again, to attest what Steve's saying, never an issue with anything at all. Not even a complaint. Never had to work anything out with them. The cars parked in the front. I guess when there was a party or something like that, occasionally they would spill out in the street a little bit. But ever since his restaurant opened, great, big success, but there was the trucks and the violations, which it sounds like I've missed. They corrected those. Unfortunately, they corrected those, it sounds like with some effort, not on behalf of good neighbors. They corrected them because they probably were forced into a compilation a year ago, it sounds like. I missed that. I wasn't there. I don't live there full time. I'm working there full time. So that doesn't demonstrate great behavior, a good neighbor when you have to wait till you're forced to correct something. The violations are still going on with the parking. And I know we're not here for that, but I have to say it actually impedes the delivery of mail. So they park their cars sometimes, and the mail doesn't come till 8:30 at night there, unfortunately. And we've missed mail deliveries because they can't get to the mailbox because cars are parked there, even though we have signs saying no parking. Cars knock over signs, that the parking signs on the corner there. I have plenty of pictures on my phone. Anyway, the catering argument or defense, it's been beaten about, but I'll just second. The town is sort of on the hook here. They need to clarify this clearly, that there's some issue, but maybe this is the perfect example. We take this and make an example. Please, when you're doing it, take into account what Steve said about all the uses for the catering. I've also done catering and I worked that business. Where are they cleaning all of the utensils and all the items for the catering? Where are they cleaning the trucks? Where are they servicing the trucks? It's these are questions that need to be factored in, and how many meals are being prepared there that are factoring into the pressure on all the services that are necessary for that, the water, et cetera. I hope the parking gets corrected. I know it's separate, but it is a big issue still. And there's still catering trucks parked there. I don't know, every day they're parked in the gated area, and they're just not being utilized. No one's actively using them. They're parked there, whether they're there at night or not. But to say they're not parked there, they're parked there. So that's what I see.
Thank you.
Yeah.
Okay.
Sorry, Michael. Yeah.
And your 28.
28 minutes.
And are you going to be submitting those pictures as part of the record? You would have to print them and email them.
Yeah, we'll determine
Unless we
that.
keep the record open. Right.
Anybody else from the public like to speak? Okay, thank you. Council, I'll ask you to come up, and if you have any closing remarks, please.
Excuse me,
Oh,
CBA,
yes, do we have anybody?
have one caller holding?
I'm sorry, yes, go ahead, Matt.
Okay, we are going to unmute the last four digits, 4656.
Hello, caller, please identify yourself.
Never mind, we lost connection.
Okay,
continue.
thank you. All right, Council.
Just to briefly acknowledge, address some of the things. One of the questions was if it was one business without DBAs, would it be legal? And that's why I believe we came here, because as an attorney, in order to advise my clients, we would need to know if there was one business, then what's the line of accessory catering to, principal use? Mr. Shantz used some key words, I think, that are very important. Accessory, ancillary, and one of the other ones is immediately subordinate, right? So one of the things here is, well, is this business immediately subordinate to the other? Well, there's no definition of immediately subordinate in the town code for us to be able to analyze it. So that's where we believe one of the problems is that irrespective of the number of businesses, and I'm not saying that what we're doing as inferred before should be considered one, but what I am saying is that's why we're here. We came here to understand where that line between accessory and principal is. And we do not believe respectfully that language is included in Ann Glennon's letter or interpretation that would allow us to, so that's why we're here. So if we get back to that aspect of it, that's why we're here. Then it seems like, again, respectfully to the community members, this business didn't open up until the world changed, right? So this business, Rita Cantina, did not open up until May of 2020 when the entire world had already changed. So we understand that we're doing an analysis to, okay, what was it like at this location before? But let's be honest with yourself. The east end of Long Island, specifically South Fork, saw record numbers of real estate purchases and people moving to this community that never lived here before. So we understand, but it seems as though that things are being attributed to my client as far as to catering, where respectfully, you can't attribute those things. The parking aspect of it, respectfully, has nothing to do with catering, because the catering doesn't even increase the number of employees that go to the Rita site. because there are no employees of of the catering that work at, unless you call, Eric Miller and the principals of the companies, they're the ones that have the dual purpose in both within catering and the restaurant. But, I would submit to this board that, while we acknowledge many of these, concerns of the members of the community, we submit that they're absolutely not related to catering. So it's not catering that's increasing or causing a parking problem. It's not catering that caused, this gentleman from not being able to get his mail. The parking problem has been a problem at this location inherently, it seems like forever. And Mr. Walsh, highlighted some very key points. And those are things that are inherent to the site and have nothing to do with my client's operation. The building itself and the size of the property and its proximity to the roadways, proximity to the town's right of way, all these things are inherent in the property itself and have nothing to do with my client's
And
specific
they're not
use or
part of what
operation.
we're here tonight either, so, right, whether we're here to look at uses, right?
I understand, sir, but it seems like both the board, the members of the community, the questions from the board members, a lot of the things had to do with things, those related, like the pictures that were initially put up, 90% of the pictures that were put up when we started this, had to do with the parking and all those. So I'm only addressing them only because they came up tonight. If the board doesn't want me to, speak about these
That's fine.
topics, we don't have to.
Right, okay.
I just have another question going to the appeal. You filed this appeal in March 2022?
No, ma'am, I believe the
Well,
code says
around
we
that
have
time.
30 days. So I think it was back in like April, we did this appeal.
Okay,
Or
but you
April
did
or
not
May.
appeal this going back to August of 2021?
We did not. No. No, there were other issues with that. I mean, there was a record stated with respect to when there was a service. We'd have to look at the record, but I will tell you that the August letter was not served on the property owner or the applicant at that time. It wasn't received until sometime thereafter.
After August 17th, 2021?
Yes. I don't know the specifics. I'd have to speak to the property owner, and I'm sure we would have a record of that, but yes, that, and I wasn't retained on the planning board application at that time either.
Okay, is that a factor in the appeal, the date?
I unfortunately don't know the history of the facts of that situation, so I'd have to look back and figure that out, and I'll get back to you guys on that.
Okay, thank you.
Thank you. Thank you, members.
So
of
the
board. I
question
appreciate your
is, the
time.
question is, do we close the record or tonight, or we hold it open? I'm not aware of any request from the board or from anybody else other than getting pictures for us keeping the record open.
Yeah, I would only request that the board keep it open for my purpose, for just a limited purpose of the affidavit of service being resubmitted for
Right, so how,
checks and
right,
balances.
so how much time do we need for that? Are we allowing for that?
Very minor clerical hours, so it's just a matter of us reproducing the affidavits of service. We just got to get them, one of them is myself, so that we can turn around very quickly. The other one is my client. So, I mean, I would assume, I don't want to say by the end of the week, just because I have,
We'll leave it open for a week?
yeah, I think that would be
Till
fine.
next Tuesday?
Sir, that would be plenty of time. Yeah.
Okay,
If it's solely for the purpose of the submission of those affidavits, and that's rather quick.
okay, so we're gonna leave the record open for 1 week. If public, if you wanted to submit photos, you have a week to do so. Beyond that, they won't be accepted. Okay,
I don't know if there's anything else that the board wants me to submit that we would submit in that period of time. We're happy to, obviously address any of the concerns or anything that we could produce. We'd be more than happy to do so.
okay, thank you.
Thank you very much. Thank you, everyone.
Right,
I'm fine with closing.
Yep. Denise?
Okay. In the matter of the appeal of Miller Brothers Hospitality, I make a motion that we keep the record open for 1 week for the resubmission of a corrected affidavit. And we close the written record. Close the public hearing.
Close the public hearing and keep the record
Keep the
open.
record open.
We have a
I
second?
second, I second that.
I concur. Okay,
I concur as well. Thank you. Thank you, everyone. Thank you. Okay, so next, we're going to, our next hearing this evening is Tallmadge Farm LLC at 464 Old Stone Highway in Amagansett. Suffolk Tax Map Number 300-103-2-11.2. The applicant is Tallmadge Farm LLC. The size and location is 94,231 square feet at 464 Old Stone Highway in Amagansett. The description is to allow a 39.75 square foot shed, a 57.34 square foot dovecote, and a 55 square foot pergola to remain on a property respective to side yard and pyramid setbacks. The relief sought is 5 variances are required. Variances of 18.2, 4.5, and 18.4 required from 255-1110 dimensional setbacks to allow a shed 1.8 feet, a dovecote 15.5 feet, and a pergola 1.6 feet from southern, northern, western side yard where 20 feet is required. The variances of 83 cubic feet and 374.6 cubic feet are required from 255-1172D to allow a shed and a pergola to remain within the town's pyramid setbacks and any other relief necessary from the East Hampton Town Code. The zoning district is A2 residence zone, X flood zone, and the secret class is type 2. Council, do we have a proper affidavit of service and posting?
Yes, we do. We have proper service pursuant to chapter 255 of zoning.
Thank you. Council, we did not do a board member did not take photos for a report.
Okay.
So I've asked Brian if he can maybe pull up some of the photos from the existing conditions.
Okay.
Good evening, Mr. Chairman, board members. These are photographs that my coworker, Eleni
Brian,
Nikolopoulos.
maybe I'll swear you in first.
Sure,
You
that's why I'm
swear
here.
for him to tell the truth, the whole truth, and nothing but the truth.
I do.
Thank you.
As I was saying, these are photographs. They were taken, I believe, on November 18th, 2021 by my colleague, Eleni Nikolopoulos, who reviewed the application. And I'll go through them as best I can. As you know, the application is for 3 distinct structures, a shed, a dovecote, and a pergola. And I think the photos are kind of grouped in that order. So this is the shed. There are several photos of the shed up against the, I believe it's the southern property line.
I'm not aware of a dovecote ever before us, ever before.
Ever. I had to look it up, see what it was.
I'm a birder. And I have to
Good.
What?
Another view of the shed. As Eleni, well, anyway, I'm just going to run through the photos. If you have any questions about them, please ask. And a similar photo to the first one. Again, the shed, this is facing south towards the property line. This is the dovecote.
Now, where is that on the survey, Brian?
That's going to be on
Right here, Terry. That's the one right there. To your
right-hand
left.
side of your survey.
To your left.
On the
on the-
right-hand side of the survey.
Rear yard.
Photos on the,
You can see the shed and I saw the pergola, I think.
Oh, west.
the west,
The
the very
west
far,
side,
the very
okay,
far
so
one
it's
over there to the right, no, upper right. I
Oh, way out
Yeah,
here
there
in
it
the
is.
corner?
believe that's it.
You think that's, okay.
Go ahead.
Thank you.
Yeah, it's west, my mistake, I apologize. These are just different angles. It's, you know, the highest structure involved. And this is the pergola. And
Okay,
that's,
thank you.
I'm sorry, Brian, where is the pergola on it? Or do you know?
Pergola is
On the north,
right there. It's up on the upper part, right here, right here. Yeah, right there.
Okay, it's called Arbor, okay.
All right, do we have a council applicant here?
Evening, board members. My name is John Huber,
How are you,
attorney
John?
for the, of Dayton, Voorhees, and Balsam here in East Hampton. 231 Pantago Road, Suite 1, East Hampton. Attorneys for the applicant, Tallmadge Farm LLC. We appreciate the time and other resources you've devoted to this matter. Applicant seeks 3-yard and 2 pyramid setback variances for 3 accessory structures at the subject premises, 464 Old Stone Highway. May I request, excellent, thank you. I was going to ask that we put the survey up. I can, if I may, I'll just step over to the survey and I can show you quickly where these are.
Yeah, you can show us quickly, then get back to the mic so that we can get
Yes,
get
sir.
on the record.
This is the shed located on the southern property boundary. This is the dovecote.
Oh, there it is.
Along what I would refer
That's the dovecote.
western property boundary. And this is the pergola located along this northern boundary. To help you put this in
Okay.
context, the property owners have traditionally called this the shade garden. So during my presentation, I may refer to it. And also one other thing that might be helpful, if any of you are familiar with the Lieber Collection Museum at 446 Old Stone Highway, that's located in the back here. And as I'll explain in my presentation, this is the former home of Judith and Gerson Lieber. And they used to use this as their private access when they would do presentations at the Lieber Museum. So they would pass here through the shade garden, through this gate to get over to the museum. The subject parcel, improved by the main house, outbuildings, and extensive gardens, was the home of the late Judith and Gerson Lieber, both internationally renowned for their creative endeavors. In 2008, they established the abutting Lieber Collection Museum at 446 Old Stone Highway. Mrs. Lieber was celebrated for the handbags that she designed and produced from 1963 until her death in April 2018. According to the Lieber Collection website, Mrs. Lieber's handbags are included in the collections of various museums, such as the Metropolitan Museum of Art, the Smithsonian Institute, and the Victoria and Albert Museum in London. Mr. Lieber was a noted modernist painter, lithographer, and sculptor. His works have been exhibited at over 200 national and international shows and are part of permanent collections at the Metropolitan Museum of Art, the Smithsonian Institute, the Brooklyn Museum, the Seattle Museum of Art, and the Malmö Art Museum in Sweden. The Liebers first acquired the property in 1956, and they acquired some of the abutting parcels in the decades that followed. During this time, they developed the property into what it is today. If I may, I'd like to hand up to the board several copies of a Smithsonian Gardens booklet that I obtained from my due diligence in working on the file from the Smithsonian Institute itself. This booklet contains an extensive series of site photos taken in 1984 by the renowned garden photographer Ken Drews. And these photos emphasize the remarkable results of the Lieber's improvements at the site and the truly unique nature of this property. So maybe if the board doesn't object, I'll put up a copy here, and then one down this end, and then one in the middle, and at your convenience if you like.
I'm going to hand one to Laura.
needs one.
And so she's going to have to post this into the public record. Okay.
The structures that we are discussing tonight were designed by the Liebers and constructed under their direction and supervision. In a very real sense, these structures, particularly the dovecote and the pergola, make up an important part of the property's extraordinary provenance. If I can, I'd also clarify for you, a dovecote is a very an ornate manifestation of a pigeon coop. And as you can see, based on the grand nature of the property, a pigeon coop, it would be a little too simple for the property. It's very elegant. So they designed a dovecote, very much inspired by English gardens. The Liebers traveled extensively in Europe and were inspired by what they saw there, and they tried to recreate that at this property. The applicant is the current owner of the property who purchased it in 2020 after the estate issues were resolved and the property was available for sale. I submitted on October 13, 2021, a set of photos, eight photos in this packet. If the board does have those photos, they may be helpful for you. They comport very nicely with the photos that Eleni took. And if I may, while I'm at it, I really want to compliment Laura and Eleni and working with them and getting this application submitted. They were excellent, collaborative, and supportive, and they made the process go as smoothly as it could possibly go. So in my photo packet that I submitted, photos 1 and 2 depict the shed. Photos 3, 4, and 5 depict the dovecote. And photos 6, 7, and 8 depict the pergola. A brief summary of these structures and the requested variances as follows. The small shed, constructed in the 1990s, is located approximately midway back along the property's southern boundary and was used to house irrigation equipment when the Liebers owned the abutting parcel at 201 Neck Path. I'll step over. This would be 201 Neck Path here in the lower left corner on the screen.
That property has since been sold?
Correct.
Okay.
Although 201 Neck Path is no longer part of the former Lieber property, today the shed is used for yard equipment storage and houses an electric sub-panel to service outdoor lighting and other outdoor electrical needs. The variances we request for the shed are an 18.2 foot side yard variance and an 83 cubic feet pyramid setback variance. Please let the record reflect that on October 13, 2021, we submitted a letter of support from Mr. Iqbal and Ms. Jensen, the current owners of the abutting premises at 201 Neck Path, and they have no objections to the presence of the shed. They support the application. The dovecote, located approximately midway along the property's western boundary, appears on wall bridge surveys as early as May 12, 1984. A simple one-story extension on the dovecote's east side was added in the early 1990s. Interestingly, that dovecote is covered by the 1985 certificate of occupancy that was issued for the property. Although I believe that at that time, the small extension, which is actually not even part of the variance, did not exist. We request a 4.5 foot rear yard variance for the dovecote. Please let the record reflect that on October 27, 2021, we submitted a letter of support from Sandra Bennett-Vatter and Michelle Vatter, current owners of the abutting premises to the north at 189 Neck Path. That would be this property up here. The survey indicates their names, Vatter. So that would be right here. The Vatters do not object to the application, and they support it as indicated by their letter of support. Finally, the pergola, located approximately midway along the property's northernmost boundary, was constructed sometime in the mid-1990s. As our photos 6, 7, and 8 confirm, the pergola embodies the unique ornamental nature of the gardens and the various outbuildings. The variances we request for the pergola are an 18.4 foot side yard variance and a 376.6 cubic feet pyramid setback variance. The relevant area variance criteria are set forth at New York State Town Law, Section 267-B, Paragraph 3, and East Hampton Town Code, Section 255-8-50, Paragraph 8. In summary, the variance criteria applicable to these structures is as follows. The overarching balancing test, whether the benefit to the applicant, if the variances are granted, will outweigh the detriment, if any, to the health, safety, and welfare of the neighborhood or community. The primary benefit the applicant seeks is to preserve, to the fullest extent possible, the property's existing character and configuration, as well as its provenance. Insofar as these accessory structures have existed for decades without incident, demolishing and/or relocating them would unnecessarily disrupt their broader relationship with the other structures on the property and would be contrary to applicant's desire to preserve the property's unique character and functionality. Moreover, under the unique circumstances of this case, requiring the applicant to demolish or relocate these structures would cause unnecessary expense and inconvenience.
Just question.
Yes, sir.
Couldn't anybody come to us and say, we want to preserve the unique character of our property and the structures we built thereon?
Sure. And I think that, but the applicant should be required, as I'm prepared to do tonight, to qualify why they're asking for that relief and really help the board get comfortable with the totality of circumstances underlying the situation.
Proceed. You can go.
And hopefully when I'm done or conclude my presentation, you'll see that we're sincere in our request and that within the context of the measuring tools we have, these criteria, that we really do satisfy those criteria. So if the board decides to approve it, I think that your decision would be rational and based on the substantial evidence in the record. And certainly if you decide that you want to interpret that differently, I respect the board's decision.
Thank you. Oh, that's fine. You proceed.
Okay, so if, final point on the overarching balancing test. After so many years allowing, these are very low intensity structures. I mean, they're for reflection and meditation and quiet walking on the property. Maybe, one or two people can go sit in the pergola or stand by the dovecote. So they're low intensity accessory structures, and we ask that you allow them to remain as they are. They do not pose any detriment to the health, safety, and welfare of the neighborhood or the community. Criteria 1, whether an undesirable change will be produced in the character of the neighborhood or whether a detriment to nearby properties would be created if the variances are granted. Again, after so many years, allowing these minor accessory structures to remain as they are in their remote locations on the sprawling property would not produce an undesirable change in the neighborhood's character and would not be a detriment to nearby properties. Criterion 2, whether the benefits sought by the applicant can be achieved by alternative feasible methods aside from the requested variances. Demolishing and relocating these structures would not be practically feasible for the applicant, particularly insofar as each of the subject structures is integrated with the overall configuration and uses of other outlying structures and the gardens. For example, the shed is in a well-concealed and unobtrusive location. Since it was first constructed in the 1990s, it has been used to support property maintenance and infrastructure. Demolishing and relocating it would necessarily require the applicant to relocate the electrical subpanel contained therein and certain outdoor light fixtures. This would in turn require retrenching and other unnecessary site disturbance. Likewise, demolishing or relocating the dovecote or the pergola would unnecessarily disrupt their form and function, particularly with respect to adjacent and outlying property features such as access walkways, plantings, ornamental and otherwise. Is that for me?
Yeah.
Timer? Okay, I'll be quick. I'm almost done, actually. I want to hit the last two criteria and I'll be
I have a
finished.
question when
Thank
you're
you.
done.
Okay, so access plantings, access walkways, plantings, ornamental and otherwise, and the strategic locations of these structures within the overall site layout as intended by the Liebers when they designed and installed the gardens decades ago. Criteria 3, and perhaps the most important, whether the requested variances are substantial. The requested variances are not qualitatively substantial, especially when we consider the totality of circumstances underlying the application. These are unobtrusive, low-intensity use accessory structures which have been in place for many years without incident and are not visible from any publicly accessible locations. Of the 5 variances requested, those that could be considered quantitatively substantial are the yard variances for the shed, the pergola, and the pyramid variance for the pergola. As for the shed, the board might consider that as a small 44 square foot structure that is very well concealed by surrounding vegetation and the adjacent fence to the south. As for the pergola, the board might consider that it too is a small 55 square foot structure that is located in a remote, densely wooded portion of the property, hence the term shade garden. Criteria 4, whether the variances will have an adverse effect or impact on the physical or environmental conditions in the neighborhood or district. This is a type 2 action under our state environmental quality review regulations. As a result, these structures are deemed not to have a significant environmental impact and are precluded from further environmental review. Criteria 5, whether the alleged difficulty has been self-created. Applicant, the current property owner, did not create the conditions for which the subject variances are requested and seeks the specified variances in good faith so that we can obtain an updated certificate of occupancy for the property.
When the property owner, when did the present property owner take?
2020.
Okay. So if he took property, ownership of property, it's, and takes over ownership, non-conforming use, structures like here, isn't that self-created? Doesn't that fall into self-created?
I understand your point. They, perhaps if you allow me, they took title to the property knowing that there were non-compliant conditions that had to be remedied. So they closed in about April of 2020 or September. And then by December of 2020, Inspector Rigo went out and inspected the property to issue pursuant to their requests for an updated certificate of occupancy and delineated the conditions that he believed required further action. And then we promptly acted on this to begin the compliance process.
I understand.
Okay.
I have a question.
Yeah, me too.
Go ahead.
Well, you have one more point. Let him finish his point. then we'll-
Yes, actually very quickly. So whether it was self-created, we discussed that. And the final criteria, insofar as the subject structures are existing, have been in their current locations for decades, the requested variances are the minimum necessary to afford applicant the benefit it seeks while preserving and protecting neighborhood character and the community's health, safety, and welfare. Based on the foregoing, I request that the board grant the relief applicant seeks, and I'll conclude my presentation there unless the board has questions. Thank you for the
There we
opportunity.
go. Go ahead. Joan, you wanna go?
I'm just curious, the Lieber House, is that, are they preserving the Lieber House as well, or?
The museum, if I understand correctly, is
No, the dwelling on the
the
property.
dwelling itself is not of any independent designation as a historic structure or otherwise.
Just curious.
So are the new owners planning any other changes on this property at all?
That was my next.
Well, we've
question.
discussed it and they wanted to see what the outcome of the zoning process would be. For example, thank you, Ms. Berger, for asking that question. As you can see, some of the changes that are contemplated, some of these structures require attention, obviously. So if we come to the fork in the road and the board approves the structures where they are, then they can be restored to a condition that's aesthetically pleasing. If I may, for example, if you look at the photo, this is all densely wooded. There's a lot of native vegetation in here. And the way the walkways are constructed, the pergola in its existing location could be restored without any site disturbance or disruption of the vegetation. It's one of the lovely aspects of the property. If this we were required to demolish this and relocate it, it would, among other things, disrupt the vision that the Liebers had for the property. We would have to locate it elsewhere and do some clearing on the property. So that's one of the reasons underlying our request to maintain location.
Now, that property also is privately owned. That's adjacent to that pergola?
This property here?
Yeah, that's what it looks like on the survey.
Yes.
Okay.
Any other questions?
Yeah, I see that in the photos and on the survey that there seems to be a 6-foot stockade fence that basically surrounds the property. It's certainly behind all three of these structures.
Yes,
correct? That's pre-existing. I see in one of the photos that you provided for us. Let's see which one it is here. I think it's photo 6 now. I see a brand new section of stockade fence here, photo 3, out beyond the dovecote. And the dovecote, at that point, I'm looking also at vegetation that is off this property. There's some vaulted evergreens, it looks like. Perhaps I'm wrong with that. But anyway, there's some vaulted tree mass behind that. That's off this property. Is that correct? The large
Forgive me,
vegetation
sir.
behind.
I'm not exactly clear about what.
But what I'm basically getting at here is that there's a lot of mature vegetation in the photos you've given us.
Okay.
And that's probably because of the long-term use as a garden area.
Yes.
And behind these sheds, they were all pushed off to the side. So that makes why you're here for variances. And behind each of those, there is a 6-foot stockade fence.
Okay.
There also is quite a bit of mature vegetation. Now, normally, one of our considerations would be for us to talk about covenanting vegetation to protect neighbors. It seems as if most of what I'm looking at that's mature is off of this property and on another property. Can you comment on that? Do you know that that's the case?
Sure. I mean, I will. It's very important to me that I respond directly to your question. It's difficult to discern what, if any, vegetation that's inherent to this property is encroaching onto abutting properties. This is all around the perimeter here is all densely vegetated. We have excellent relations with all of the neighbors, and there were no complaints amongst the abutting neighbors. And I imagine that if anyone was uncomfortable with the situation as it was, they would certainly very amicably resolve those issues amongst themselves.
Right, but we're not in a position to covenant what we see that is on another property. So most of the mature vegetation here that is protecting this property now, and it seems quite attractive, most of it is on other properties. It's off of this particular property because I can see clearly it's beyond the 6-foot fence that you have behind it. Most of all three structures are fairly close to a property line. That's why you're here. And we can see a distance behind there where there's a fence. And then beyond that is mature vegetation. All very attractive, but not under the control of this particular owner.
Understood. May I just take a moment to respond very quickly then?
Yeah, please.
So I think it might be helpful if we go structure by structure and then address it in that context. So the shed.
But let's limit it in time, John. We're, so I know we want to go structure to structure, but we can't go on all night long. We have other questions.
I understand. Okay. Well, any vegetation on this property, I suppose your concern is that what if one of the neighbors decides to clear away some vegetation on their property?
That's right.
And as a result would make one or more of these sheds more visible from those properties.
That's correct.
Without being evasive, I guess we would have to cross that bridge when we get to it. This property owner has submitted a letter of support. This one has too. And as you can see on the survey, there's structures, it's sort of, not that this is an excuse to have non-compliant structures, but there are existing conditions on the abutting properties to sort of establish a course of dealing amongst the neighbors. Thank you for your question.
Okay, thank you.
What else, Terry? Oh, Denise?
I have a question. Mr. Huber, I completely appreciate the neighbors not having a problem, but these decisions do run with the land. And one of the measuring tools that we have to address as a board is compliance with, can this be variance standard? Can this be achieved by some other method other than an area variance? Now, the TAM is suggesting that there is room on the subject property to locate structures in conforming locations. So I just want you to know, as a board, this will be discussed. And how would you address that?
How would I address that? Thank you for asking that question. Within the totality of all the different criteria that we need to examine, whether or not there's a feasible alternative, I would suggest perhaps we look at that objectively and say, is it feasible within the totality of circumstances of existing conditions and also within the totality of the criteria and in the balancing test? And then each of the individual criteria guide the board's deliberations in achieving the balancing test. So I'm certain that if you looked at one of the criteria and said, gee, they could have been stronger on this criteria or another criteria, but within the entire context of the application, I would suggest to you that the boards, if you were inclined to approve this, I think it's rational based on the evidence that's before you. Especially, I'm unaware, I don't know if you have any neighbors that are objecting, but there's no public opposition.
Now, but the neighbors change. Presently, there is no opposition. You are correct about
So
that.
my question is, your argument seems to be that collectively these things work out, but individually, from a dimensional standpoint, these are very substantial variances, both in setbacks and in pyramid, right? I don't know if, and I know that some of these structures were built without the benefit of a building permit as late as the 90s, from what you're saying. And I know this board has denied sheds with almost 100% variance requests that were done as early as the 90s. So I'm struggling to see the true uniqueness. I don't see how these three things can be combined. I'm just struggling with it. It's a big stretch for me to be going in that direction. I've never seen it. I don't know if there's a precedent for it. So that's the goal. Each one of these things, being there a long time, certainly we can take a look at, I would say. But this is kind of an interesting one.
I mean, one of the arguments you made is that it's integral to the way the Liebers designed the garden. Do we have any assurance that they'll continue to maintain the Liebers design? That makes sense, because that's the totality. I mean, I'm just looking at the Smithsonian thing. The totality is the Liebers designed this garden in a certain way, or this property in a certain way. So you're saying, well, maybe the house isn't worth preserving, but can you represent that they'll maintain the garden this way? I'm trying to throw you a softball.
Sure, I understand. So certainly the principal assurance that you have is that any alteration they would need to come before the town for permits to do any work. For example, if we do proceed and restore the pergola, we need a building permit for that. So the town will have an opportunity to vet anything that's proposed. At this point, there's as I am unaware of any intention to demolish the house. The intention, as far as I know, is to keep the house, the footprint of the house where it is. I don't know if I responded to your question, but the town would have an opportunity by enforcement, and then eventually, if and when we clear the zoning board, we will have to have the final inspection to get that certificate of occupancy. And the board's decision would be part of the record, and certainly that's going to establish an important part of the record in the way this property is managed going forward.
So we do know that dove coat, based on these photos that you presented, I guess this document from the Smithsonian, but those photos were taken in 84.
Yes, sir.
So the dove coat, it's at least existed in 84.
Yes, sir.
And from the look of it, although they're fairly fresh, it was probably not done that year. So we're talking about something that the dove coat being there 40 years, basically.
Yes, sir. The dove coat.
And you said the dove coat was on a C of O at some point.
Yes, the 19. Yes. Interestingly, the dove coat is in the Smithsonian packet that I handed up.
Yeah, we see that here.
And the only, and it's that rear part of the dove coat that's in proximity to this western boundary line. The extension that was added, the one-story extension, was done in the 90s, is in a compliant location on the dove coat on the east side. So it's actually doesn't even run afoul of the setback that we're seeking a variance from. And I agree, Mr. Chairman, this case does present some interesting questions to be pondered. To sum up, then, if the board's concerned about establishing a precedent, et cetera, I've done my level best to try and distinguish that this is such a unique situation that we do qualify for the criteria for the variances. And if someone comes forward in the future to and uses this as a precedent by which the board is bound, I think they'll have some difficulty establishing that their property is at least as unique as this one. This is a really...
What is that uniqueness? Is it because it's the
Well, you know, I thought about this. What if this was John Lennon's property or anyone of note? Does it mean that noteworthy people can get away with whatever they want and then go and say, hey, look, I'm so-and-so and I did what I want? And that's not the argument that I'm making. It was really important to me when I stood before you tonight that I not come across as saying, look, these are special people who deserve special treatment. I think it's the property is special in its existing configuration, and very simply, it does satisfy the criteria for the area variance. There's no adverse impact on the community. This is not about giving special people preferential treatment.
Thank you.
Any other questions?
Let's hear from the planner.
All right, thank you.
Thank you.
Brian?
Good evening again, board members. Brian Frank on behalf of the planning department. I'm going to change the view for a second, one to the aerial. And then I do have the 95 CO here, and considering the emphasis on it, it might be worth taking a look. So I'm bringing up the aerial now. The property is highlighted in blue. Some of the other neighboring properties, the other Lieber property that Mr. Huber mentioned in this presentation is up here. The Neck Path property, I'm sure Mr. Huber could point out more effectively than I can. But this is a 2.1 acre property. It has been before the board before for a front yard variance in '94. It's been the subject of a planning board review for a lot line modification. Other than that, it's fairly unremarkable. And it really is the board's role to evaluate what Mr. Huber has presented as the circumstances of the property against pretty objective variance standards in the town code. Obviously, this is not a natural resource application or the presence of protected natural features here. But nonetheless, this is what zoning boards do across the country, is they evaluate New York State town laws cited by Mr. Huber and our variance standards, and they apply them to dimensional applications like this. This property is, among those variance standards are the substantiality of the variance. These variances are pretty hard to say they're not numerically substantial. The lot is 2.1 acres, and there are a lot of conforming locations on the property where these or similar structures could be located. The owners bought the property just 2 years ago with knowledge of their existence, and in other applications that's been a contributing factor to whether the need for the variances is self-created or not. As Eleni noted in her assessment, there was a pigeon coop on the survey on the 1995 certificate of occupancy. The shed and the pergola were not. I was looking in my file here, and I see the 95 CO and the 85 survey. I don't see the 95 survey, and that's why I'm gonna, if you want to take a look at it now, I'll bring it up. If you just want me to make sure it's in your file before you deliberate the application, I'll do that as well. We've been talking about this for a long time, and the issues are pretty black and white here. I will point out that in addition to the availability of conforming locations, the lot is considered cleared according to the town code. There may be, and it's been a long time since I've been at the property, but it is pretty well landscaped, but it is landscaping. It's not natural vegetation that's protected by the clearing restrictions of the town code. And I don't think there are any legal protections for anything on this property. If it were the owner's intentions to redevelop the property, I'm not aware of anything. It's not in a historic district. Again, there are no protected natural features. There are no clearing limitations. I'm not sure what would preclude the property from a complete redevelopment if this or a subsequent property owner desired it. That's pretty much all I have. If you want to see that 95 CO now, I'll bring it up. If not, I'm just going to make sure you have it in your file.
Well, Brian, it's on the C of O on the survey, you're saying, because it's not on the property card for 95 C of O.
No, I'm sorry, I'm not sure I understood the
I
question.
don't see a pigeon coop listed.
The dove code is on the 95 survey, she's asking. Is that what you're saying?
Maybe it wasn't called out. I guess I should bring it up.
I don't see it on the property card listed as a pigeon coop.
I mean, we know from these pictures it existed in the 80s.
This is what we had.
The dove coat.
Maybe they call it something different.
Pardon me, I've got to zoom in a little bit here. This is from 1995, and perhaps I'm mistaken. I don't see the notation. The pigeon coop. I apologize. Here it is back here. Just a different structure. It's smaller. I don't know what the height was. But that's again, I'll make sure that you have a copy of this in your file.
So,
but it's not on the C of O.
right.
Sometimes that happened during those days, but still the survey is part and parcel of the C of O.
Harry?
It was not uncommon for a small accessory structure like that in the 90s. not
Look
to
at the
call that
town
on a
notes,
CO.
the picture was listed on the,
Yeah.
It's on the survey.
listed on the CO.
Yeah, she says C of O, but it doesn't.
Information, there were a number of certificates of occupancy issued for this property.
In
There was a
95?
certificate of occupancy issued, it's certificate of occupancy number 5402, dated January 24, 1985. And it covers the residence, one-story frame shed, pigeon coop, studio and garage, pool equipment, pool house, and pool, second pigeon coop. So the pigeon coops, dovecote, for tonight's purposes, were both appeared on the 1985 CO. And then, so for whatever ministerial reason, I suspect the 95 certificate of occupancy was just, doesn't mention the pigeon coops because the inspector went in just for purposes of the improvements that were done specific to the house. So they may not have carried forward all of the other things that were addressed by previous certificates.
We'll look at it.
Thank you.
That's good.
Any other questions?
Brian, are you done?
No.
Yes.
Oh, thank you.
Anybody else from the public here? Matt, anybody on the line?
You have 0 callers. Thank you.
Okay, thank you. I think we can close the record, right? Joan, or I have it in front of me, so maybe I can read it in. Therefore, I make a motion to close the public hearing and the public record for Tallmadge Farm LLC at 464 Old Stone Highway in Ameriganza, Suffolk, tax map number 300-103-2-11.2.
I'll second it.
Okay.
I concur.
Thank you. Thank you, John.
Thank you. Well, thank you.
Stuff confused.
I know.
All right, our next hearing is John Nicholas, and I'm sorry you waited all this time. Is John Nicholas at 16 Mulford Avenue in Spring, Suffolk, tax map number 300-38-7-15. The applicant is John Nicholas. The size and location is 115,495 square feet at 16
Yes.
Mudford Avenue in Maidstone Acres, Section A, map number 664 in Springs. The description is to construct floating rafts for the cultivation of oysters. The project consists of floating rafts with 7 tray racks suspended beneath each raft, lantern nets suspended from rafts, and floating upweller systems. And the relief sought is a natural resources special permit pursuant to 255-420 of East Hampton Town Code. The zoning district is A residence, 8E flood zone elevation 7, and secret class is type 2. And I must say, this is an evening of first. The first
Yes.
subcoat and the first oyster service.
I
So,
will do my
so-
best with this field inspection.
Okay.
Council, do
You
we
can
have a
tell me later,
proper
John, how
affidavit,
it-
proper affidavit of service and posting?
We do have proper service posted pursuant to chapter 255.
Okay. This is the official notice. It has been properly posted. Was there on Saturday? Okay, now. This central portion, the subject premises is situated within the northeast or Maidstone area of 3 Mile Harbor. And their marina is converting a portion of this area into an oyster farm. This dock that you are looking at is the central portion of the property which contains this area of docking. Also with offshore pilings, and it generally docks 8 vessels, but for the purposes of this oyster farm, these boats that are generally along here will be eliminated. Next, Brian. This is my photo. A lot of the area of this area is going to demonstrate where the oyster nursery is going to be operating. So that's another shot of the same angle. Next, Brian. Okay, this entire area is the area that's going to, it's now going to contain, and if you look at your survey, and a very, very detailed narrative was submitted. This is the area that's going to contain 5 flupsies, which are all also powered by 3/4 HB ice eaters, 18 floating raft cages, and it will take the same, it'll take the space previously occupied by the boats. So the project on the other side of that dock where the boats are will not go beyond 33 feet. All these structures are shown, all of this is shown on the January 27, 2022 survey. Next, Brian. This is the south side of the marina, and this part of the marina, these boats are expected to stay. Next, Brian. This is again a shot. Also in this area, the raft cages will be utilized when the oysters outgrow the flupsies. All of the equipment that we're talking about is going to be floating and is going to be connected to this existing dock that you're looking at. Also, in addition, there'll be 200 hanging lanterns, which are essentially mesh bags, which will be hung out on the flopsies, floating cages and existing walkways to the bulkhead. Next, please. This is just another visual of the same shot. This is the area where the oyster farm will be. Should be more, I think. Is that the last photo bar? This is just racks that I found, oyster racks that I found on the property. This is, as you navigate out of Sunset Cove, which is where this is where you leave and you're actually entering into the 3 Mile Harbor Channel. And that's really what this photo represents.
That's the last photo.
I also thought there was a photo of an electric box. It is, you can see it on the survey. And that's going to deal with frozen water and will also work with the 3/4 HP ice eaters. So that's my field inspection.
With tiny box.
Thank you. Any questions? I have questions, but not from Denise.
Yes, thank you.
Hi, Laurie. How are you? You want to announce yourself?
Yes, Laurie Wiltshire for Land Planning Services.
You swear affirm to tell the truth, the whole truth, and nothing but the truth.
I do.
Thank you. Proceed.
So I'm here on behalf of John Nicholas and the East Hampton Oyster Company, which proposes to install flupsies, floating rafts, cages, which are not on the bottom, and 200 hanging lantern mesh bags for oyster cultivation, and to operate an oyster nursery and grow out facility at the Sunset Cove Nursery Facility in 3 Mile Harbor. Sunset Cove Marina will reduce the number of boat slips from 22 to under 10 and will cease to operate as a conventional marina. They will still be classified as a commercial marina by New York State, Suffolk County, and the town of East Hampton for rental boat slips, but those boats will be used in conjunction with the residences on the property and the oyster cultivation operation. So the oyster nursery will take place in the space that previously occupied the commercial boats that rented space there. Well, they weren't commercial boats, but they were private boats that rented space there. No equipment will touch the bottom of the bay. All equipment will be secured to the existing wood pilings and the existing floating docks and poles. The waterway is seasonally certified, and the Oyster Company plans to operate as the Sunset Cove Nursery year-round and abide by all New York State DEC regulations. They have obtained all the required permits from the New York State DEC, and I will submit that to your file. Laura, thank you. The oysters will be transported from this site to a processing facility elsewhere. The company will follow all the town trustees, ZBA, and New York State DEC regulations. Basically, they'll be adding millions of oysters to the East Hampton waterways and improve water quality and overall environmental health for everyone, particularly considering this was an operational.
This is a commercial
marina.
This is a commercial operation, right? So
It is a commercial operation, but I'm going to let John Nicholas sitting here address all the aspects of this business.
Okay.
So that's John, the owner and founder of the East Hampton Oyster Company. This application was originally slated to go administratively because there was no potential environmental impacts associated with it. However, there was one letter received during the 20-day period, comment period from the East Hampton Landings Homeowners Association. Their concerns were twofold, that perhaps this would impede boat traffic in the channel because there's other waterways that traverse behind where these boats used to park. Mind you, those boats were pretty deep out, and this is going to be much more narrow in its use of that channel. So there will be no impeding the boat channel. And they were concerned about potential noise. And basically the responses to that, oops, where'd they go? Oh, the responses to that were that the floating rafts will only will not exceed the 36 the area currently occupied by the boat slips, They will not float into the middle of the channel or impede boat traffic in the channel. And this was confirmed by former Harbor Master Ed Michaels, who confirmed that in writing to John.
Do we have that in the record?
Yes, it actually is.
Oh, it is in the record.
Yep.
It is in the record.
And then concerning noise, the marina currently has and uses 7 ice eaters sporadically. That was for the boats that used to dock there. And the use of additional ice eaters will not be in continuous use. They're occasional use, daytime use. And the Sunset Cove Marina and cottages have up to 14 people living there. So their efforts to keep things on the quiet side are obviously to their advantage. And also whatever they're doing there is going to be noticeably quieter than 22 boats coming and going on a regular basis. So that's my introduction to the project. And then I'll let John answer.
Look, just a couple, maybe he can come up too, but the lanterns, what are the lanterns?
I'm going to let him speak to the oyster operation.
Come on up. And is this something that has to go, is this like a planning board thing too? Does it go before the planning board? No.
No.
Okay.
John Nicholas, 16 Mudford Avenue.
All right, John, do you swear affirm to tell the truth, nothing but the truth?
Yes, I do.
Thank you.
The lanterns are, they're lantern mesh bags. They're like 5 layers and they have a Velcro opening so you can access each layer. They're used because they can fill in small spaces to maximize.
Are they lanterns?
They're mesh bags.
But that's all, they don't emit light or anything.
light?
No, they just call them lanterns because that's what they look like. They're in the water and they're
And
just
then
different
the
layers.
noise concern would be from the pumps for the ice, for ice protection or?
The oysters, clarify your question exactly.
Looking at there was a complaint.
Right, well, there's ice eaters used in the
That's
flupsies.
when the noise happens, and
Right.
that's in January.
Yeah,
typically,
well,
or February.
we're working on modifying and reducing the amount of noise in the flupsies.
How would you describe that noise?
It's the ice eaters.
I mean, it says ice eaters, so I'm just saying it's nothing that's that particularly loud. It's not a piercing through the neighborhood. kind
No,
of sound.
no, it's more like
It's like
the
a
water is churning.
Yeah.
The water is churning.
And isn't the electric box that we talked about, isn't the electric box less?
The electric box is for the bubbler system. That's a air compressor that's wrapped around each of the poles and releases air so the ice doesn't form around the pylons.
And the ice eaters are only used when there's ice, Mother
Right,
Nature
right, but then
provided
there are
ice.
ice eaters in there is ice eaters in the flupsy also for a period of time. Underwater.
In terms of concerns people had about navigational safety, we did speak about how this wouldn't go beyond 33 feet.
Right, the channel or the pathway for the boats out of this area is on the other side. And there's no, people don't pass that close to the boats that we have now. And they're not going to, we've had boats up to 36 feet in length there, and this will only extend 33 feet from the dock. So it's not going to extend much further from where the boats already are right now. We're basically exchanging boats for oysters.
Right now, it's in a marina with boats.
Right.
Yes.
Will there be any change in the land portion of this where it's going to look like cages and stuff that might be a eyesore or something like that in the future?
We do have cages there already because we operate in Knott Peak. So there is cages on the property. Or there's several hundred cages already on the property. But no, we're trying to minimize as much I live on the property. I want it to look beautiful. It's not going to be any kind of an industrial, operation.
And these cages, I was there, and it does look nice and neat. It was not like in the center. It was off to the side of the property. It wasn't an eyesore to look at.
Well, one of the reasons I asked if there was a planning board, and that is to identify a site plan where, that stuff is controlled over time.
Right.
Right. I know now it looks good, but,
But we
that's the
don't,
only reason I asked about it, but
I could eventually come and ask for a facility to store some of this equipment. Right now, it's,
yeah, that would be a planning board thing,
Right,
or,
that would be a
and it
planning
would
board.
come to us again for an NRSP.
right now, there's no storage, there's no storage. Everything is outside.
Okay.
We're replacing outboard engines with filter feeders, basically.
Yes. And we hope to make an example of marinas converting to oyster farms, not only for Long Island, but for, all of the East Coast. It's one of the first project to take a marina and convert it into an oyster farm. We think it'll be a nice example to compare what the water was and the plant life and the growth now compared to annually each year, to see what changes while the water gets cleaner and hopefully other species come into the area, plants and other animals.
Interesting.
Yes, very.
Okay, no other questions for me. Anybody have any questions?
I have no questions.
Brian?
Good evening, Mr. Chairman, board members again. Brian Frank on behalf of the Planning Department. I've left the survey up, or the site plan rather. This is obviously where the oyster farm is proposed. The other improvements on the property are cottages, which are more properly defined as resort units and by the town code, and a single family residence in the southern part of the property. I'm going to just switch over now to an aerial, because there's been a lot of discussion of this area and the conditions there. I have one that's closer in if the board wants to see it. Here's the subject property. This is the marina where there was some concern expressed about the impacts to navigation. As the chairman had mentioned, this is the first oyster farm that we have reviewed a natural resource special permit for. In reviewing this application, it was noted that they had their shellfishing permit from the DEC. We evaluated it against the natural resource special permit standards. And if this were the type of activity that disrupted marine habitats, resulted in a loss or diminishment of marine life, or clearly impacted navigation, we would have processed it administratively initially. We had to, I think, respect the concerns that were expressed, since they represented a homeowners association, and this represented a unique application for the planning department. So it didn't seem the appropriate application to proceed with an administrative permit with the knowledge that there was community objection there. That being said, the zoning board needs to evaluate this against the natural resources special permit standards of the town code. Really, the one that's the most pertinent is under the specific standards of the town code, and that's 255, 551. Letter E applies to coastal structures in general. And when we think about coastal structures, we're usually talking about docks and bulkheads and more traditional coastal structures. But these rafts are a type of coastal structure, and that's why it needs a natural resources special permit in the first place. And in evaluating this project against those standards, the planning department didn't identify any adverse impacts that would be incompatible with those standards. I think that's pretty much all I have. I thought I had a picture of the lantern bags. I apologize, I couldn't find it.
Of the what?
The lanterns, the mesh bags.
But they're bags, they're not.
They're bags. They're hanging bags. They look a little bit lantern shaped.
Okay.
And I think that's where they get their name, but they're bags.
All right.
And they hang above the water?
No, they hang below the water. I'm going to let the applicant explain it.
Yeah, they just hang in the water in areas that are open.
And just to be clear, because the public may have this question as well, excrement is not a potential problem with a farm of this size. I know they're a filter feeder and what they're doing in terms of their normal process, but when you put that many individuals in one spot, do you anticipate that as any kind of potential ecological problem?
The excrement is algae.
Yeah.
And this would make up a fraction of the already decaying algae in the water, a very small fraction. They eat algae and their excrement is, recycled algae. So
small percentage of what they've taken.
Very small. There's a tremendous amount of algae in that waterway.
Yeah.
And the excrement would mount to a extremely small amount of the overall natural decaying algae already in the water.
Okay, thank you.
So Brian, in the TAM, it pretty much says you feel it's an environmental improvement because there'll be reduction in propellers and boats.
This is a shallow water marina, and any place you have boat traffic in shallow waters, and you saw from Member Savary's photos, it's a low wave energy environment, so there's a well-developed salt marsh around it. Boat traffic has the ability to both create turbidity, bottom scour, and the wake action of boats has the, alternate flora doesn't do well in higher wave energy environments. So this was perceived as a less intense use than the traditional marina. By the way, bivalve excrement is called pseudofeces. And it actually builds the marsh. That's, I don't want to get too disgusting, but they spit it out. They don't have an
It's a breeding tank for oysters.
and that's what helps build the marsh is pseudo. So I think there, Member Johan's point is that at some point, the circulation of the flupsies, the discharge water on a very large scale operation does have the ability to impact water quality. And I believe those are the parameters. I believe that's, one of the parameters that the state looks at in issuing these permits.
Okay, just out of curiosity, you have recommended project conditions E, no new lighting is authorized in this permit? Does that relate back to the lanterns?
None has been proposed, and that's kind of a standard condition in dock permits, just to make it clear. If any were proposed, we'd have to take a look at it. There are standards for marinas and power pedestals and lighting. Basically, you want to keep light pollution. I don't know if you've ever been on the water and you've seen housing spotlights kind of used shining out on the bay, but that's incompatible with the NRSP standards.
Okay. There's also no dredging, but no equipment touches the bottom. None of this equipment will touch the bottom at all.
Any other questions?
Is this thing for getting a permit from the building department?
What do you mean?
Get building permit?
Well, yeah, once we
What
get
kind
a
of permit?
resolution
Yeah, what-
adopted.
Do you go to the building
I don't know.
department at all?
I think we're gonna be-
Brian, what happens with that? In this case, do they have to go,
Process.
once we make a determination, do they have to go to building permit for it or?
I'm not certain, but I believe so.
Yeah, okay, good.
I mean, yeah.
It's
what
another
else
first for them too.
Yeah.
I think I don't want to overspeak. I didn't discuss it in that level of detail with the principal building inspector. We did discuss, there was an initial a discussion with the planning department about the need, whether site plan would be required for this project. A determination was made that site plan would not be required, but a natural resource special permit would. I don't know if the electrical connections with the flupsies and the other components require a building permit.
They're all existing. All the electrical outlets are all there for the boats.
Yeah.
Right.
And fresh water too.
Well, it's a beautiful in there. It's a beautiful sanctuary. I paddleboard in there quite often.
It is
so
a
it's
beautiful
really
spot.
beautiful to go in there. So,
Interesting. So residential.
I'm gonna be
Anything else,
going.
Lori? Matt, anybody from the public want to speak? Matt, any callers?
We do have one caller holding, yes.
Okay, call her in.
Okay, last four digits are going to be unmuted of 7439.
Hello, caller.
Okay. Can you hear me?
Yeah, you want to identify yourself?
This is Susan Jewett, and I am the president of the Homeowners Association of the East Hampton Landings Homeowners Association. Can you hear me?
Susan, do you swear affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Okay. Am I on?
Yes.
Yes. I wrote a letter as president of the Homeowners Association concerning this project, and I have not received any response, nor did I get notified about this public hearing, which is disturbing. And so I just wanted to say my piece. Is this the time to do it?
Yes.
Yes. Okay. So this is a very shallow inlet, Sunset Cove, and the only deep water is in the channel that leads to our marina, the Folkestone Marina. And I've spoken to John about this project. We have nothing against oyster farming, nothing at all, and I think it can improve the water a great deal, so that needs to be said right up front. The concern I have, I read through John's whole proposal, and it stated that the mean, I may not have this exactly right, but because I'm not at home with my notes, but the mean low tide was like 4.5 feet, and the mean high tide was 6 or 6.5 feet. And that is inaccurate. It's not that deep in this cove. It may be that deep in the channel. And so what confuses me is that this equipment apparently is not supposed to be touching the bottom, and if there are aerators below the rafts, they need some depth. When I first heard about this project and read about it, it happened to be right near low tide, and I went down to look at the spot where these are proposed to be placed, and it was about 1.5 feet deep. So I don't understand how the floating rafts and the aerators are going to manage in such shallow depths. So our concern, so that's sort of an aside, but you know, if in fact he has to move this equipment to deeper waters, the only deep waters are in the channel. And we have many boats in our marina that use the channel. So our concern was simply that there may be intrusion. If he, in fact, needs to move the equipment to deeper water, we're afraid it might impede the channel. So that's the only place we're coming from. And I never got a response to my letter. I don't know if anybody's paying attention to this. I don't know if anybody looked at the depth of the water there. But this is of concern to us. Can you respond to that,
We
please?
only use the first 2 feet of the water. The raft only uses 2 feet of water.
Is this John speaking?
Yes. Yes, the water, the raft only goes down. Hi. It only goes down 2 feet.
Okay, with the aerator below it?
Just want to make sure there's not a debate going between public and you, John. So please address the board. Let her finish, and then maybe you can address your comments to the board.
Okay.
Okay, well, I'm really about finished. That was my concern. Some of the neighbors had concern about possible noise and truck traffic. That wasn't included in my letter. I was addressing the channel. But we just need reassurance about these issues, because I wanted the town to weigh in on this, and we hadn't, like I say, heard nothing back from the town.
Okay, thank you.
Thank you.
Okay. Hey, John, you can comment if you.
The FUPSI, as you can see from the diagram, it only goes down 2 feet into the waterway. So it just floats 2 feet below, and it's more than 1.5 feet of water for all those boats, a lot more than that. So.
Okay.
Let me just address the notification issues, which, so basically when the East Hampton Landings Homeowners Association wrote this letter to the planning department, it's considered a comment entered to the which actually caused the public hearing,
Part of
and
our
becomes
record.
part of the public record. So it's not like the town was going to respond or we were going to respond, except for here at this hearing, which we have done, about depth, the channel, impeding the channel, and the noise. As to the notification, only the immediate neighbors get written notification, but the property was posted on 2 different roads. So I believe anyone in this homeowners association would have seen this hearing was coming up.
Okay, thank you. Good?
Okay.
Thank you.
Thank you.
Denise, you want to close this out?
I certainly would like to. In the matter of John Nicholas, 16 Mudford Avenue in Springs, Suffolk County Tax Map Number 300-38-7-15, I make a motion to close the public hearing and record.
I'll second.
Concur.
I'll concur.
I concur as well. Thank you.
Good night.
Thank you.
Good night.
Good night.
All right, moving right along.
Okay.
We have 2 administrative hearings this evening. The first one is Mark and Alita Hornfeld at 16 Dune Way in Amagansett, Suffolk Tax Map Number 300-176-3-16. And the description is to construct a 112 square foot shed, 96 square foot shed, 32 square foot outdoor shower, 55 square foot barbecue with 43 square foot patios, 170 square foot of walkway, 661 square foot of pavers, roof overhang, and approximately 2,856 square feet of revegetation on a parcel of land containing dunes and beach vegetation. Brian?
This property is on Dunecrest Way in, Dune Way in East Hampton. It's a property, there are a couple of structures that were built without building permits in the southeast corner of the property where they would require dimensional variances. The application is to remove them, construct a shed and an outdoor shower in the northern portion of the property, and revegetate the area around it. This is the survey. I have an aerial photo if you want to see what the existing conditions are on the property. There are wetlands. This isn't to scale, I don't think, this line. There are wetlands about 200 feet away to the east, to the west rather. And the planning department has looked upon this as some minor changes to the improvements of the property.
How did the revegetation factor into your determination that it was minor? The revegetation, it says here about 2,800 feet?
Well, any of the disturbed areas need to be revegetated. Just that would be a fairly standard condition of approval. And on occasion, they incorporate that re-veg as part of the application. And I think that's what happened here. This is Tyler's application.
I mean, I looked at this, I'm fine with this. Anybody else?
I'm fine with it too. I am.
Mary?
Yeah, okay.
And it looks like an improvement.
Mm-hmm.
I think in the bottom line it is. I think when you first read it and you see that many requests, it stops you for a minute. But I think that seeing that they're moving it from one place to another in a more conforming location.
Here they are. There's a pretty big dune in the westernmost portion of the property. It's protected by a scenic easement.
Right.
I believe this area was cleared recently for the installation of an IA system that was on the survey. There's a lot going on, so you might not have. I wonder if I still have it right. No.
And the things that are going to be removed were already removed there?
I don't believe they have been removed yet, no.
Okay.
Yeah, I'm okay with it.
John, you want to make a motion?
Yeah. In the matter of Mark and Alita Hornfeld, 16 Dune Way, Amagansett, Suffolk County Tax Map 300-176-03-16, I move to allow this to go administratively.
I'll second it.
I concur.
I concur as well. Thank you. Next, we have Lauria Trust at 47 Kirk Avenue in Montauk, Suffolk, tax map number 300-5-4-12.1, and that is to relocate an approximately 76 square foot non-conforming shed to a conforming location, allow an approximately 46 square foot shed to remain, and to reconstruct existing decking on a parcel of land within jurisdiction of freshwater wetlands. Brian?
Yes, the survey is, well, the structures are small, so it's hard to see. I'll go back to the aerial in a minute. There are some substantial wetlands to the east and more isolated wetlands to the west. This is the 46-foot square foot shed that's being requested to allow to remain. This shed, you can't see it. It's a little bit less than 10 feet from the northern property line and would need a variance from the property line to remain where it is. So you can barely see where the lines are, but the application is to move it to a conforming location in the gray lines here, to move it so that it's 10 feet from the property line. The closest wetland is 115 feet away. You can see from the aerial, there's an improved property in between it and the wetlands. So here's the shed that they're going to relocate. Here's the shed they're asking to remain. Here's the deck that they'll be reconstructing in place.
Okay, Montauk?
Well, I don't have a problem with it.
I'm okay with it. I'm okay with it too.
Okay, who wants to make the motion?
I'll make the motion. Okay, for Lauria Trust at 47 Kirk Avenue, Montauk, tax map 300-005-04-12.1. Make a motion to allow this application be processed administratively.
I'll second it.
Concur.
I concur as well. We have two decisions to make, but Brian, I'm wondering if we should jump down to other decisions in case you want to go, or what's your?
Well, I'll stick around. So it's up to you. Thank you for the offer. If you want to skip, I'll bring them up. We have the plans in the survey. It's kind of been a practice lately since we've had these hybrid, this Zoom and in-person meeting to bring the surveys up of the properties that we're talking about.
Okay, so then we'll.
Oh, I see what you're saying.
Yeah. So then we'll read in Clifford. You want to stick around for the two decisions, or?
I can't wait.
He looks excited.
First, we have Clifford Shapiro at 8 Ocean Lane in Ameriganza, Suffolk, tax map number 300-176-3-10. The size and location is 12,000 square foot at 8 Ocean Lane, Hampton Dunes, lot 30, map number 4694 in Ameriganza. The description is to construct a 638 square foot first floor addition, outdoor shower, approximately 180 square foot of decking, hot tub, relocated pool equipment, AC units, LP tanks, generator, approximately 182 square foot of garage, bin, driveway extension, fencing, sanitary system upgrade, and clearing within the jurisdiction of freshwater wetlands. The relief sought is a natural resources special permit pursuant to 255-420 of the East Hampton Town Code, and one variance is required for this application. One variance of approximately 22 feet is required from 255-430 of the Town Code to construct the proposed fencing 78 feet from freshwater wetlands, where a 100-foot setback is required and any other relief necessary. The zoning district is B residence AE flood zone elevation 10, and the secret class is type 2. And I believe the applicant resubmitted a survey eliminating the variance for the fence.
Did they?
Yes. Ed, maybe you want to take a shot at it?
Yeah, this was Member Brenneman's last meeting that we had before he retired from the board. And I'll try to parse through some of what we had that was that he brought up at that time. That hearing was held, board will remember that the hearing was held on May 24th, 2022. We were working from a survey of November 11th, 21. As was read in by the chair, it required an NRSP and a variance of 22 feet for a fence, which is, since the fence is moved, that variance has now been eliminated from our consideration. There were no wetland variances here. A number of things were brought up about this when we discussed it. It's a 12,000, I can get exactly here for the record, but it's a 12,000 square foot lot. Can you see here? Oh, yeah.
It's exactly
It's just 12,000 even,
yeah.
okay. I thought it was a number in there. 12,000 square foot lot, so it's a small lot. And we have, we're looking to do some improvements here, both in an addition, a detached garage, and a couple of other small ones here with this outside shower. One of the things that came up right away was our concern about the amount of development on a lot this size. The lot is, as we've just mentioned, only 12,000 feet. Any addition here, any hardening of additional space here is going to allow for gathering and runoff of waters that might not be contained. There was a question of the dry well locations and capacity. Would they be improved enough to offset any of this potential new gathering rainwater? And although that was addressed, it was still a concern of ours. We did have 2 letters from neighbors on this one, and both were, of course, not of course, but both were contended that this was a mistake allowing this additional work. And they pointed out that the flooding in the area has been a significant issue over the years, and in particularly seems to be increasing with all new purchases on land. Now, the property was bought only recently. Again, I have it here somewhere. And is it right here? 2020, 2021, someone help me out with that. We don't have it here. Okay.
Somewhere.
Well, I want to get it right. We're going to put it in the record here. But anyway, given the size of this property and given what we're asked about in terms of approving an NRSP, we have to consider what we are interested, this is my take, what we're interested as a board in approving in terms of the amount of development on a parcel this size. When I look at this, I think the proposed garage has the greatest possible impact on wetlands, the opportunity for it to gather water and distribute water. The dry wells aside, it still increases in permeable surfaces, and it has the potential to impact that. They're moving from an existing lot coverage of 1295 going to 1950, where 24 is allowed. The lot coverage increasing as it does, it gives us back into a situation where what are we as a board interested in doing in this very sensitive area and limiting development? I thought that although case was made by the applicant's representative that these on the surface were not large asks, although there's 628 square foot addition, but it was over a previously disturbed area, and they made a case for that. I still think that in this circumstance, where we're working here, under these conditions of a very small lot in an area that's extremely sensitive to water runoff, I'm not looking to approve this variance. Approve this application at this time. Again, as was pointed out by the letters from the neighbors, which were pretty comprehensive, this has been a problem that we see increasing as it's within that area. And I think we've addressed this with some recent applications also down in the Beach Hampton area. So I'm not going to say any more about it. I'm going to say that I'm not willing to approve it at this time.
Thank you. Terry, you want to try it?
Yeah, I have a, okay, there were actually 3 members of the public that called in the night of the hearing, Jack Hassett, Jane Meering, and Rona Klopman. 2 of those are their homes are immediately adjacent to this property. And as Co-Chair Johan said, they were concerned about the totality of the project and the flooding conditions that they feel will be exacerbated in this neighborhood if this project were to be approved. Okay, they've eliminated the variance. I didn't see that new survey, but you did. Everyone else did. So
I'll give you the
okay.
date. It is.
I didn't either, Terry.
I have it right here in front of me, and the date is June 3rd, 2022 revised plan.
Okay, so
Drainage
that's
and-
the revised survey. Okay,
Yeah.
thank you. Yeah, so it's a 638 square foot addition. As Vice Chair Johan said, my major concern, even the night of the hearing, was about mostly about the garage area. There are very few garages in this area of Bridgehampton. The lots are very small. At 12,000, this may be one of the larger ones actually in some of these properties. But 638 square foot addition, was increasing it from 2,041 to a proposed 2,679, where 2,800 square feet is the maximum allowable. It was to, include a gym and office. The garage was, they testified it was going to be used for storage, but the location of the garage was immediately adjacent to one of the public's, Jack Hassad's property, and he already had concerns about standing water and water conditions with the groundwater at other times with some of just the normal rains that have occurred in this area, and concerns about the separation to the groundwater. In the TAM, it was stated that the proposed garage was likely to have the greatest possible impact within jurisdiction, second to the proposed additions. Overall, I think this is a stretch on an overdevelopment on this property. There are a lot of things going on this property, and I'm concerned about the construction that were to take place with it. And I don't feel that, I feel that it does not meet the natural resources special permit standards, and that it's too much of a development in this area. So I too am looking to deny the application.
Thank you. Denise?
I agree with my fellow board members. This parcel, which is pre-existing non-conforming, already has a 2,041 square foot residence, which is 97 feet from the edge of wetlands, decking, shed, swimming pool, outdoor shower, septic system, and driveway. The first floor addition will increase the size of the residence from 2,041 square feet to 2,679. My concern is this is where 2,800 square feet is the maximum allowable. They are just maxing out the numbers. And an upgrade on a septic system, I don't feel should be intended to increase the size of the house. And it's really not enough to mitigate the increase in the size of the residence. I think the garage, I feel, will have the greatest impact on the wetlands. This lot coverage is close to maximum allowable, and additional development on this site is just not suitable. This appears to be an ongoing problem. We're being asked to allow unsuitable development on undersized lots, and this is something that falls into that category, being only a 12,000 square foot lot. The parcel also has, over the years, back in 2008, was given relief to construct 650 square feet of deck addition, 700 square foot roof deck, cleared vegetation, and alterations to the residence already. I think this site has reached a point of saturation and is really not in keeping with the standards for any additional development. The potential for flooding, impact on natural resources / natural features, and vegetation make this application a poor candidate for the grant of a natural resource special permit.
Thank you, Denise. Joan, Leanne?
I didn't participate in this. Thank you for asking.
All right, then, I too will agree with the board on this. I think that once again, we have a redevelopment of a already developed property that is near maxed out already. It's quite busy, and the development proposed will literally bring it up to the threshold of maxing out. But however, this property stands within NRSB jurisdiction, and I feel that, not that I feel, it exists very dynamic wetlands within this area. And further development, I think, will impact those wetlands. We did have comments from neighbors with photos. We know the wetlands here. We know the problems with them. And I think as far as meeting the NRSB standards of 255-51, D 1 and 2, and then 255-540, G and K, as mentioned in the TAM, I think that it fails to meet those criteria. So with that, I also vote to deny this application. Council, we okay?
Yep, sounds just okay, based on the requirements of the town code.
And this was a recent purchase, and I thought I had that date written down. It
What's
was
that?
with it, there was a recent purchase, this house of
Yeah,
the
I
read
current
it
owner.
somewhere.
I
Thought it was
don't know
20.
why I don't have the date here. So they were aware of what they were buying when they bought it.
Correct.
Yeah.
All right, so next we have Maureen Goldberg at 28 Holly Hill Road, Narragansett, Suffolk tax map number 300-127-2-50. The size and location is 20,818 square feet, 28 Holly Hill Road, Devon Woods, map number 4824, Narragansett. The description is to construct a 484 square foot garage with quartz driveway, a 256 square foot addition to the residence to allow a 5.25 square foot generator and a brick walkway, stone patio to remain on the property, and to remove a 151.3 square foot shed, 112 square foot deck with outdoor shower, and a 36 square foot brick walkway on a parcel that contains freshwater wetlands. A natural resources special permit pursuant to 255-420 and 4 variances from 255-430. Wetland setbacks are required. Variances of 11 feet, 29 feet, 54 feet, and 72 feet are required to allow the proposed garage 89 feet, proposed addition 71 feet, existing generator 46 feet, and existing brick walkway, stone patio, and 28 feet from wetlands where 100 feet is required. Any other relief necessary from East Hampton Town Code. The zoning district is B residence, Zone X flood zone, and the secret class is type 2. Who would like to?
This was mine.
Okay, go for it, Denise.
Okay. Rather than go into a public hearing summary, I'm going to render a determination now and base it on what happened at the public hearing, because the format of the public hearing was slightly different than what we originally do. There was a lot of back and forth, so I'm going to render my determination in that fashion. This is a 20,818 square foot lot. The public hearing was originally scheduled for May 24th and was rescheduled for June 28th. The survey, I believe we're working from, is October 1st, 2021. The applicant has agreed to remove a 151.3 square foot shed, a 112 square foot dock with an outdoor shower, and a 36 square foot brick walkway because of the parcel's freshwater wetlands, and these structures are very close to them. This action, however, should not be taken as mitigation since these were all illegal structures built without a permit. As a condition of their approval, I would like a revegetation plan submitted to the board prior to the issuance of a building permit, which would consist of primarily woody shrubs and to be implemented on the entire area prior to CO. The proposed addition to the residence is only slightly expanding a 224 square foot current sunroom / porch to 256. This is an already existing area, so I am in favor of granting that addition. The brick walkway on the south side, which I had a lot of discussion about at the hearing, according to the applicant's attorney, are important to get around the house, and if not, they will destabilize the area, causing the hill to break down, erode, and slump. Essentially, trying to make the point it provides safety. I was initially inclined to not grant this because of its close proximity to wetlands, but after some thought, it does seem to have been there for many years with no apparent environmental impacts. And as a condition of that approval, It was agreed at the public hearing that a scenic easement should be established along the 18-foot contour line as illustrated in the planning department sketch and submitted to the zoning board prior to the issuance of a building permit. This scenic easement will help, in my opinion, will help address the NRSP standards. In terms of the generator, the attorney for the applicant noted removing the generator would cause a disturbance. The generator is in close proximity to the wetlands, and in the past, the board has requested generators be located as close to the residents as possible. A 54-foot variance is not the minimum necessary and therefore not in keeping with the code, especially if there is a more conforming location. The garage, as per the TAM, the quality of the wetlands on this property cannot be overstated and can be expected to provide all the benefits typically associated with high-quality freshwater wetlands. The attorney noted that the garage would be to keep the car obviously out of the elements and also for additional storage. And in light of the environmental constraints on this property, I do not find this parcel suitable for any more additional development, and I'm really not in favor of approving the garage. Planner Tyler Borsak noted that 255-1-D-2, which could move a garage to a principal setback requiring a 10-foot variance, is in the code. It's not in the TAM. And I did research that, and that section of the code does not really change my thinking in terms of the garage. Upgrading the septic system was initially problematic. However, after a lengthy discussion, the record was left open for 30 days for further submission and consultation with the applicant regarding upgrading the sanitary system. The board during the public hearing did express concern that the current system dating back to the 60s with cesspools does not meet Suffolk County Health Department standards. Planner Borsak noted the issue of the GFA is what really drives the septic system improvements, not the effluent from additional bedrooms. And as per a letter submitted September 19th, 2022, the applicants have agreed to upgrade the septic system. I do want to make a note too that I don't know if we've gotten a new survey. I think a comment was made by Mr. Irace that during the discussion of the garage and the discussion of the septic system and the well, he came back and I think he said it was noted well that the well is near where the garage is proposed. So I don't know if we have any further information on that, but I'm not in favor of the garage. To summarize, I'm in favor of the addition and walk-stone patio and upgrading the septic system, but I am opposed to the garage and the generator.
Thank you. Mary?
Okay. Well, I went through a lot of the same process. Yeah, there was. And initially leaving the hearing, I was not in favor at all of this project. And as stated by Member Savarese, looking at the illegal structures that I think you called it a dock and it's a deck. But,
Did I?
Yeah,
I'm tired.
Yeah, it should be. It was the shed and the privacy wall around that wood deck with the shower that was in the shower was already gone, I believe, in your photos.
Yes, it is.
Yeah.
It is already
So
gone.
that, I too feel that's not mitigation. Okay, well, let me just cut to the chase. I am looking to approve the extension now and the stone patio. And with the upgrade, all of that because of the upgrade to the generator, the septic system rather. The generator I'm still leery about. I'm willing to have it stay in the location where it is. I don't know if an IA system might cause that to be moved elsewhere anyway, and if so, certainly move it further away from the wetlands, but I'm willing to approve it as is, if necessary. And I'm also looking to approve the garage. And I did think it was a good idea suggested by Tyler that we could give a 10-foot variance and allow that garage to move 10 feet farther away from the wetlands and toward the, for the front line, front property line. And I think all in all, with the scenic easement at the 18-foot contour, the revegetation, which will have to be approved by the planning department, and the generator that I'm looking to approve this project. And the generator alone, I feel, is a substantial improvement to the environmental conditions. Did I say generator? And then septic system.
I know, I said
Okay.
dock, meant deck.
So you're
So
approving
I'm
everything.
willing to approve everything.
Thank you.
yes.
And yeah, I'll follow the lead of my fellow board members and say up front that I'm looking to approve this application, and I'll explain why. I think the night of the discussion, there were several issues that came up to us. One was, as was suggested in the TAM, that we follow the 18-foot contour line and establish an easement below that, which is directly above, in this case, the wetlands, and that would receive a revegetation that would be approved by our planning department, and therefore would be an improvement over what's there. The removal of the sheds, while not direct mitigation, nonetheless is an improvement on the parcel. So I think that was a positive, although it should not enter in our decision making. I think when we were at that meeting, we pressed the representative of the client for the septic system, because we all felt that the septic as it was, as dated as it was, going to a cesspool, it wasn't just an outdated septic system, it was a cesspool, and that should have called for immediate improvement. There was a reticence on the part during the discussion that night, but as was pointed out by fellow board members, later on, we did receive new word from them that they were willing to put in the IA system. The generator is, of course, could be moved, but the generator will now have a responsibility for, hopefully help control what's going on in the IA system. And I think that I'm willing to allow that to be there. I thought that the effort on the part of the applicant to come back with the IA system swayed me into thinking that this was an application I could approve. I also considered whether or not moving the garage 10 feet mattered enough to ask them to do that. Moving it closer to the front to Holly Hill Road is a negative. Moving it further from the wetlands is a positive, but I'm willing to allow it as it sits right now. I'm not sure in terms of impact on the neighborhood that it's the right thing to move it even closer to the road. So in total, I'm willing to approve this application as it exists. I looked through the standards here, and I think that what was offered by the applicant help raise this to the level of which we could find approval under both NRSP standards and on the building standards here in terms of setbacks.
Thank you. Jonas, you weren't here again, so I assume. Thank you. I agree. I don't have much to add to this. I do agree. I will approve the entire application. I do feel the mitigation proposed does provide the mitigation to approve this. I don't have much to add other than that. So there you go.
So where are we on the garage then?
Garage
Garage
approved.
as is with the 30?
One denial on the
One
garage.
denial.
And the generator.
You don't feel strongly about moving it the 10 feet?
No.
Okay, so I'll go with that.
So it's going where it was proposed?
Yes.
Okay.
Council, you clear on that?
Give me 1 second.
That's a complicated.
We make it as complicated.
I think I got it. So it's all, everything's approved as is. I'm assuming at the public hearing, there was some talk about the septic system, which isn't in the notes here, right? So they're going to add a septic system.
They are. That was subsequent. And we have a septic plan that was submitted.
Yeah, I just want to make it clear that it's subject to the mitigation proposed, including the septic system.
Including
upgraded septic system.
Yeah.
Okay, perfect. All right.
And the septic plan that they submitted subsequent to the hearing is dated July 20th, 2022 from TF Engineering.
Got it.
Okay, we go to other decisions. Bonnie Maslin at 307 Kings Point Road in Springs, Suffolk Tax Map number 300-24-1-11. That's possible at admin for 200 square foot of second story addition. Now, why is this in other decisions, not in admin?
Oh, I don't know, and I apologize. I don't have the survey of you know what? I'm remoted in. Give me 1 second. I apologize.
Do you have any of those? Oh, well, Brian, yeah, okay. What's the other one? Oh, yeah.
Well, you want to do,
Table it?
you want to do triple I now while he's looking?
Yeah, let's do that.
Well, we still need him to address us on it.
Not number 3, we don't.
Number 3?
Number 3, we can discuss while Brian looks it up. I'll read that in. De Marseillais at 15 Island Road, East Hampton, Suffolk Tax Map number 300-93-3-9. The request to leave the written record open for 3 weeks' time until October 4th, 2022 for the purpose of submitting a revised vegetation plan. Brian looked into this. We discussed this earlier today in our pre-meeting. Most of the time, we allow the revegetation plan to be submitted and approved by the planning department prior to a building permit. In this case, we did leave the record open specifically for a revegetation plan.
We did, and I think that was because there were other properties involved with that hearing, right?
So I mean, I think we should grant the extension of time.
Yeah, I think we should extend it also.
Yeah,
Again, if it's encompassing the whole deal.
I agree.
So with that, I make a motion of De Marseillais at 15 Island Road, not East Hampton, Suffolk, tax map number 300-93-3-9 to leave the written record open for an additional 3 weeks until October 4th, 2022.
I'll second it.
I concur.
I concur.
Thank you. Brian, you ready?
No, I'm sorry. Cracking under the pressure.
Okay, well, I can make a motion to approve the minutes.
Go for it.
Okay.
You have draft minutes?
Yeah, so I would like to make them, I read the minutes, they are good, and I make a motion to approve the draft minutes from August 23rd, 2022 for the East Hampton Town Zoning Board of Appeals.
I second.
Concur.
I concur.
I concur.
You want to do resolutions?
Should we do the resolutions?
Okay. Want to table it, Brian?
No, they've been pretty patient, and if you can be patient with me for 1 more second.
No, we'll move on. Michael and Les, move on to resolutions while you're doing that. Michael and Leslie Rickon at 22 Dune Lane, Ameriganza, Suffolk Tax Map number 300-176-4-7. I think this was.
I did this one, right? Yeah.
Yeah, you did it? Yeah, go for it, Terry.
Okay.
Oh, we're not going to get it.
Well,
Yeah, we're not going to get, she's not going to
the
know.
attorney
She's
isn't
yeah,
going
yeah.
to lead us.
Okay.
Okay.
We just give a brief summary and then we'll go back to what we did.
I got nothing for you guys on this.
I have read them all.
I mean,
I
I
mean, you
read
know,
it,
yeah.
yes, and this was a unanimous
I'm just-
denial on Rycon at 22 Dune Lane. There were a number of 22 Dune Lane.
Make a motion.
Yeah, I'm going to make a motion. I'm assuming everyone has read the draft determination. So I'm going to make a motion for Michael and Leslie Rycon at 22 Dune Lane in Ameriganza, Suffolk County Tax Map 300-176-04-7 to approve the resolution as written. The determination is written.
Second.
I'll concur.
I concur as well. Thank you. Ready, Brian?
I am.
He's ready?
Oh, he's ready.
We'll
Okay.
jump back up to
Yay.
Thank you.
Bonnie Maslin.
So you may remember this property from a couple of years ago. They came in, this is on Kings Point Road, and they came in to rebuild their rock revetment. We had a public hearing on it. It's an improved property, about a 4,000 square foot house on Kings Point Road. They're in now for about a 270 square foot second story addition. It meets the 75-foot bluff crest setback. It meets the 100-foot wetland setback. The planning department, I've been speaking with their architect about the property, and the planning department believes that it's a good candidate for administrative review if the sanitary system is replaced with an IA system. There's more to the sanitary system than the leaching pool that's shown on the survey. There's a notation for a building permit in 2005 for a 1,000-gallon tank and 300 square foot of bleaching, basically an old style conventional septic system. This property, even though it's on the Gardner's Bayside, it is in the Harbor Protection Overlay District due to its proximity to Hog Creek. It's a substantial residence now, and the planning department believes that with an IA system installed, it's a good candidate for administrative review. They have not necessarily agreed to that condition yet, but that would be a firm line that the planning department would take should they opt to say that we don't think that's appropriate. Then we will schedule it for a public hearing in any other manner. It is. I could show you the building plans if you'd like to see it. Here's the addition. This is the lowest floor is a basement. It looks like a 3-story house, but it's a 2-story with an exposed basement on the landward side. There is a second floor up there, and this is the area that they're enclosing. So there's no increase in coverage. There is an increase in GFA. And again, because the sanitary system is an old style conventional and it is in harbor protection, the planning department thinks this is an appropriate time to install an IA. And with that mitigation, the planning department thinks this is a good candidate for administrative review.
Is there an increase in bedrooms?
There is not an increase in bedrooms. It's been the planning department's position for many, many years that really, anytime you make a house larger, you're
going to absorb more people
for a longer period of time, more comfortably.
Yeah.
And the health department does bedrooms, and they count a lot of rooms as bedrooms. If you have a den, a library, a media room, they have a formula. The planning department really has kind of had it a little bit more simplistic by, bigger houses can hold more people more comfortably for a longer period of time. And that does generate the potential for sanitary effluent.
You're not asking us to make a motion tonight because it's not before us as a formal admin, or are you saying we can make a motion conditional on a septic system?
I am saying that, yes.
Okay.
That if you agree that with the septic system upgrade, that it's a good candidate for administrative review, then if they agree with that, we'll proceed with the administrative review and not bring it back to you.
Okay, great.
And the GFA you said is still well under?
Yes. Yes, it's about a 4,000 and change square foot house.
Well, good. In the matter of the application of Bonnie Maslin, 307 Kings Point Road, Springs, Suffolk County Tax Map Number 324-1-11, I make a motion that we accept the application going administratively with the condition to replace the current septic system with an IA system.
I'll second.
I'll concur.
Concur.
I concur as well. Thank you. We did do the Marcellier. We will do Philippa Abellis at 91 Gerard Drive, Springs, Suffolk Tax Map Number 300-41-2-5, and the clarification or confirmation of condition K5J, prohibition of turf, lawn, or sod. Brian looked into this as well. We discussed it earlier. There was a condition of the determination, which is at K5J. It said no turf, lawn, or sod. And the question is, did the zoning board intend it to apply to the entire property or specifically to the seaward side of this residence? The lawn exists on the landward side of this residence, right?
Well, now it's landscaping, and I shared all of this in an email to the board. So the Abellis application was a redevelopment at the north end of Girard Drive that the board approved in 2020. It was a tear down. They moved the house farther away from Gardner's Bay. Among the conditions of those approval was that the footprint of the old house be revegetated with beach grass. The application also included permission to repair the top whaler of the bulkhead on that side. And that also reinforced the need for beach grass. The property was largely cleared at the time. There was some weedy vegetation on the landward side, the west side. The planning department, it was never a recommendation in the technical analysis to prohibit turf or ornamental vegetation. There are obviously times when the zoning board asks for conditions that the planning department didn't, based on information that comes out at the public hearing or their own concerns. I reviewed, during the COVID hearings, we had that unofficial transcript, the Scribby transcript. I reviewed that. I didn't see a discussion about revegetating the landward side of the house with landscaping. And they have some issues to work out. There are some deviations from the permit that they need to address. And I'm hesitant to tell them what to do about the landscaping until I get a little bit of clarification from the board. If that was a condition that the board felt belonged in that decision, then I'll advise them accordingly. But because it wasn't very clear from the record that it was there, I'm asking the board. I'm not asking you to do anything with it tonight.
What about clearing? What about the clearing on the survey?
They're a little bit under their pre-existing clearing. I believe they're under their proposed number as well. Again, we had talked about the beach grass on the Gardner's Bay side. I've sent you I can send you the as-built survey too.
Yeah, I think typically if there's,
I don't know, it's just Girard Drive, though.
My suggestion is that you take a look at the record, take a look at the notes.
I think we should table this for a week or so. Maybe we address it next week so we have a chance to take a look at it closely.
I think that's reasonable.
Girard Drive and sides and.
Yes. Okay. Thank you. We did the minutes. We did recon Britis at 330 Girard Drive in Springs, Suffolk tax map number 300-64-1-18. Denise?
I think
That was a denial all
this was a unanimous denial.
Yes.
And in light of that, I'm in the matter of the application of Britis, 330 Girard Drive, Springs, Suffolk County tax map number 300-64-1-18. I make a motion to accept the determination as written.
I'll second it.
I'll concur.
I concur as well. Thank you. Terrace O'Connell at 9 Madison Drive in Montauk, Suffolk tax map number 300-68-2-14.1. Who handled that?
Yeah, that was mine.
Okay.
Terrence, though, there's a typo on the name, but anyway. Yeah, this was, the overhang and where there was a lot of unpermitted things, yet they got onto the C of O and all that. And I believe this was a unanimous approval.
It was.
Right? Okay, so for Terrence O'Connell at 9 Madison Drive in Montauk, Suffolk County tax map 300-068-02-14.1, and make a motion to approve the resolution as written.
I'll second it.
I concur.
I concur as well. Thank you. Then we have David Wagner at 237 Kings Point Road in Spring, Suffolk Tax Map number 300-24-1-32.
David Wagner was the bulkhead. He's one of the last existing parcels that does not have one, and he suffered a tremendous amount of erosion on his property as a result of that. So this was a unanimous approval for him to build a bulkhead. In matter of the application of David Wagner, 237 Kings Point Road in Springs, Suffolk County Tax Map number 300-24-1-32, I make a motion to accept the determination as written.
Second.
I concur.
I concur as well. Thank you.
Oh, well.
Vice Chair?
I'm trying to find the time to be sure I've got it. Okay. I'd like to make a motion to close the East Hampton Town Zoning Board of Appeals meeting of September 13th, 2022. Close the hearing, the public hearing, sorry, close the public hearing and the work session at this time at 10:07 p.m.
Second.
Thank you.
I concur.
I concur as
A
well.
little daffy here.
Thank you, Brian.
God,